I'll call the BZA meeting back to order, and before us, we have case number 6447, which is a request for affirmation and potential modification of the Board of Zoning Appeals' previous decisions to confirm that a residential addiction service facility is permitted under previous approvals for a nursing home. Now, before we get started on the case, I'm assuming that everybody signed up on the clipboard on the side. I don't see the clipboard there. It's going around. Okay, very good. I'd ask that everyone turn off or silence any electronic devices that they have, and please exit by the same door that you came in, because at the end of the day, I don't want the security people running around trying to locate you if you went out the wrong door. So with that, we'll go ahead and, Mr. Dixon, could you introduce the file for us, please?
All right, case 6447, a request for affirmation and potential modification of the Board of Zoning Appeals' previous decisions to confirm that a residential addiction service facility is permitted under previous approvals for a nursing home. The site is located at 1442 Buckhorn Road, Sykesville, on Property Zone A, Agricultural District and Election District 14, by Bay Ventures Management, LLC, Code of Public Local Laws and Ordinances, Section 158.071.01 and 158.002. A site visit is tentatively scheduled for Wednesday, April 19, 2023 at approximately 10:40 a.m. All right, the first thing I'll deal with is a request for a postponement of the hearing in a letter dated April 19th, 2023. By a G. Macy Nelson of Law Office of G. Macy Nelson, LLC. That was responded to by Kelly Schaefer Miller on April 20th, 2023, Schaefer and Schaefer LLP. And Mr. Bell wrote a response rejecting a postponement, denying a postponement, April 21st, 2023. Now, in the file, we have the site minutes for the board members. There is a April 14, 2023, letter from Kelly Schaefer Miller to Jay Voigt, zoning administrator. Purpose of this letter is to confirm and document our conversations and your opinions over the past few years related to the above referenced case. And Jay Voigt affirmed what she was saying. There's an April 24, 2023 letter from LifeBridge Health. Letter states, on behalf of Carroll Hospital Center, a wholly owned subsidiary of LifeBridge Health, Inc., I'm writing to express my strong support to request an affirmation and potential modification of the Carroll County Board of Appeals' previous decisions to confirm that a residential addiction services facility is permitted under previous approvals for a nursing home. The site is located at 1442 Buckhorn Road, Sykesville, Maryland, on a Property Zone A, Agricultural District and Election District 14. This request is by Bay Ventures Management, LLC. The proposed residential treatment program will improve access to and availability of these much-needed services for Marylanders. I understand that the center will be operated by Hygiene Detox, Inc. to provide ASAM 3 level care with 60 beds. I am pleased that patients will have increased access to these services in Baltimore and Carroll County. Maryland is suffering from a substance use disorder crisis that is devastating local communities. Marylanders deserve to have access to high-quality programs for the treatment of substance abuse disorders, and the availability of care in one's own community is an important factor to a successful long-term recovery. It is LifeBridge's intention to have a minority ownership share of the treatment center, reflecting our strong support for the success of the program. I believe Hygiene Detox, Inc. demonstrates the ability to develop strong clinical programs and provide excellent care to Marylanders suffering from substance use disorders. We do not anticipate the proposed facility to generate different or more intense use characteristics than the previous traditional nursing home operated on the property. I respectfully request that the Carroll County Board of Zoning Appeals approve case 6447. Signed, Neil M. Meltzer, President and CEO of LifeBridge Health, Inc. There's an April 3rd, 2023, notice of public hearing for this case. Hearing notice was posted March 27, 2023 by Inspector Scott Robinson. And then there is the affirmation and potential modification of previous BZA cases and confirmed permitted low-intensity residential addiction services. There's a March 23rd, 2023 letter from Kelly Schaefer Miller to the board. There's a March 10th, 2023 letter from Kelly Schaefer Miller to the board. There are some plans in here from Kennedy Porter and Associates Consulting Engineers. And there is a case 3441, a BZA case for Golden Age Guest Home, Inc., October 9th, 1990. I would ask that the file be entered into evidence.
So moved. Seconded.
Been moved and seconded to enter the file into evidence. All those in favor say aye.
Aye.
All opposed, no.
May I be heard briefly? May I be heard briefly on behalf of the citizens? I requested a copy of the file, and there are items that were produced to me, but two of the letters that were described by counsel were not produced to me. And I'd like to have the opportunity at a reasonable, appropriate time to look at those letters, because I got the file just last week from Joe Vance. And there are two, for example, there's a letter from the applicant's attorney to the zoning administrator. There's a letter from LifeBridge to the board. I've seen neither.
Mr. Chair, I do have extra copies as well, so I'm happy to pass a copy of both to
Okay,
Mr. Nelson.
thank you, Ms. Miller.
You're welcome.
But my point is, I'm here as an advocate for my clients. I'm trying to prepare for the case. We made a request for the documents in advance of the hearing. We received some, but not all of the file.
I would just say to that some of the documents came as late as today or yesterday, so.
The one from LifeBridge is dated April 24th.
I'm unaware of any that came this morning, Mr. Bale, just for what it's worth.
And Mr. Nelson, what was the other?
Well, here's a letter where counsel for the applicant is summarizing her understanding of what the zoning administrator told her on the phone. I object to this. If the witness wants to testify, he can come, but I'm going to object to this letter as being part of the record. It's hearsay, and it goes to a central issue in this case. And this was dated April 14th. We're now April 25th, 2 weeks ago. This letter was sent before I requested the postponement, which was denied. I think this is the point that my clients were entitled to see prior to this hearing.
Mr. Chair, the date of that letter reflects the date that letter was sent to Mr. Jay Voigt, the zoning administrator. The letter states that it is in the event Mr. Voigt is unable to attend personally. I do believe he is in the room here with us today. So I anticipate him testifying to all of those statements in that letter, and he did also sign that letter as an affirmation as well. So I would just point that out. But I do believe he's here and available to testify. So
I see him in the back of the room. So is that,
Well, that addresses my concern of the letter. We'll confront the appropriateness of his testimony when we get to that point of the hearing, if we get there.
yes, okay, very good. Okay, any other legal clarifications before we get started?
Yes, I have one. Mason Nelson, counsel for the citizen protestants. At the appropriate time, I'll submit a list of my clients to the board. I have a lot of clients here. I've told the board informally prior to lunch break that I don't intend to call each of them. I intend to call 1, 2, or 3, or 4, but it'll be very brief. But my main point, which I wish to make now, is I think this case concerns a pure legal question. Does the definition of a nursing home include this proposed use for the residential drug treatment program? I assert it's a legal question that doesn't require evidence.
Okay, and Mr. Nelson, I want to interrupt you. What I'm going to, let me explain the process that we're going to use. The process, and I'm not calling you down. I just want you to be familiar with the process we're going to use. I'm going to allow Ms. Miller to give her opening comments, and then I'll allow you to give your opening comments, and then Ms. Miller will have the opportunity to call witnesses. The witnesses, after they give their testimony, anyone can ask them questions of their testimony and only of their testimony. The board will get the same opportunity. Once she gets finished with all of her clients, then you can go ahead and call your witnesses, and they'll be subjected to the same rules. And then after you're finished, if anyone has any testimony they want to give that either you or Ms. Miller did not call on, they'll have that opportunity. And then there'll be an opportunity for both of you to give summation comments, and then we'll discuss the case. Okay? I promise you, as I said earlier this morning, you'll understand the process at the end of the day. So if you have any questions about the process as we go forward, please feel free to ask. This is your first time before us.
I won't be bashful, don't worry.
Okay, very good. Thank you. So, Ms. Miller, with that, I'll allow you to go ahead or invite you to go ahead and give your opening comments.
thank you. Good afternoon, Mr. Chair and members of the board. Kelly Schaefer Miller, 73 East Main Street, Westminster, Maryland, 21157. I'm here today on behalf of the applicant in this case. This is a somewhat unusual request of this board, as has been noted. We are requesting confirmation that a residential rehabilitation facility, as described here today, fits within the code definition of a nursing home. So, just for everyone's easy reference, I have printed out a copy of the nursing home code definition, and I've also provided a copy to Mr. Nelson. I don't think this needs to be entered as an exhibit since it's the county code, but
No?
Thank you, Ms. Schaefer.
this property, as Mr. Dixon, I believe, stated in his introduction of the file, has an existing BZA approval and an approved site plan for a 68-bed nursing home. The question here, I agree in part with what Mr. Nelson was stating in the code interpretation issue before you, but I think that in order to determine whether this meets the definition, you also have to hear testimony about the characteristics of the use, because without that, you can't really determine whether this meets the code definition. As has been explained in the application, my client is a contract purchaser of this property, and so we felt it was appropriate to go through a very clear and public process, having this determination heard. As you saw from the file, there is a letter from Mr. Voigt, and I do anticipate that he will testify here today confirming that this meets the definition. But it was in my client's interest to have this in a public setting such that appropriate notice was provided to everyone, and all evidence could be heard appropriately. As a quick point of order, I do believe that the board's rules of procedure state that when parties are represented, that their counsel handles the cross-examination and the presentation of their case. So I just wanted to clarify, I spoke with Mr. Nelson. He can't speak to whether there are a few people here who are not represented by him, but to the extent that the majority of those here are represented by him, it's my understanding that he will lead the presentation of that case, and he will conduct the cross-examination of witnesses, and he will call his witnesses to testify as well. So I just wanted to briefly clarify that.
That's correct, thank you.
Thank you. That concludes my opening statement this morning, or this afternoon.
Mr. Nelson,
Thank you.
you can remain seated, that way you're closer to the microphone.
Good afternoon. Macy Nelson on behalf of the citizen protestants, all of whom live in the community surrounding this proposed application. My clients oppose the application. My job as their legal advocate is to present to you the legal reasons why this board should disapprove the application. So I'll just go through those in order. The first is there's no mechanism in the zoning ordinance to allow this board to substitute one use for another, to call one use to meet the definition of a prior conditional use. That the provision in the ordinance that speaks to this issue generally is if there's a use that's not specifically designed in the ordinance, and if the applicant thinks that this use is the same as a conditional use that's defined and listed in the ordinance, you can petition for a conditional use and present the evidence that we are this conditional use, and that we can satisfy the requirements under the zoning ordinance for the approval of a conditional use. So at the outset, we say there's no mechanism in the ordinance to authorize that contemplates this type of procedure. Now, assuming hypothetically the board wants to consider the question of whether this use is a nursing home, let me outline the reasons why it's not. We know from the ordinance that a nursing home is defined. A drug rehab facility is not defined. We know from the ordinance that if there is a definition that's not present in the ordinance, we're instructed by the ordinance to go to traditional definitions of those terms. We know that much. But when we analyze whether use is permitted or not, we're trained as lawyers to look at the ordinance as a whole. And first we look at the definitions, then we look at the land use table. And what we know is we have a definition for a nursing home. We know that in the ag zone, a nursing home is permitted by conditional use. We know under the Carroll County Code that there are a very specific set of requirements for a conditional use, 158.133 subpart G. You've heard those probably 1,000 times. Every time you write an opinion on a conditional use case, you go through each of those criteria, and you make a finding of fact as to whether you were persuaded the applicant satisfied you that they can meet the requirements. That's all part of the conditional use requirement. But the point I'm trying to make is, so when you look at the totality of it, we know that a nursing home is defined, we know that a drug rehab facility is not defined, but we do see references in the zoning ordinance to a drug rehab facility. We know, for example, that if we go to the section 158.156, it lists the uses that are prohibited in an industrial park. Section 158.156, it lists the uses that are prohibited in an industrial park in this county. One use that's prohibited there is a drug rehab facility. It's in the list. A second list that's prohibited there is a nursing home. The point I'm trying to make to the board is these two uses are identified separately in Carroll County's own zoning ordinance as being distinct uses. So we assert that if you look at the zoning ordinance by itself, you reach the conclusion that the uses are separate. And then, we're trained as land use lawyers studying use, whether use is appropriate or not. We look at the purposes of the zone. And I was struck by the LifeBridge letter of support. There, I'm paraphrasing, I just heard it for the first time, but there is a statewide, Marylanders require substance abuse treatment. Of course they do. But when we look at the purpose of the ag zone, of course, we can look at it together, but I'm paraphrasing. The purpose of the ag zone, promote agriculture. The retail and commercial interests are designed to further the agricultural community. And then commercial and industrial uses are those uses intended to serve the agricultural industry and residents of the area while maintaining the character of the surrounding countryside. So we're going to ask you, when you get ready to make this legal determination, to think about that. Does LifeBridge comes in here and says, well, all of Marylanders need drug treatment. I'm saying not so fast. Or the purpose of this ag zone says that a non-agricultural use is permitted in this zone if it serves the local agricultural community. We say this does not. Now, we also know that we can step further away from the Carroll County ordinance and look at the state regulatory regime for nursing homes and drug rehab. There are separate regulatory mechanisms that look at nursing homes and drug rehab facilities, so that's further evidence that they're separate. But then, you've heard so many conditional use cases. I've advocated in so many conditional use cases, and the core aspect of a conditional use or special exception case is, what is the proposed use? This is the thought process that every tribunal goes through. What is the proposed use? So you got to picture that proposed use in your mind, and then you got to say, what effect will that proposed use have on the neighborhood, which is a term of art, around the proposed use? So you got to look, what are the land uses next door? How many people live next door? How close are they next door? What are the roads next door? Are there any parks next door? Right? These are all the factors that you folks think about every time you hear a conditional use case. And so now, here we are in the year 2023, and they come in, the applicant comes in and says, look, we want to step into the shoes. We are a drug rehab residential facility, and we want to step into the shoes of a conditional use that was approved 33 years ago, case number 3441. I respectfully suggest that you can't do that, because when you made this decision, not you, your predecessors made this decision in the year 1990, 33 years ago, that your predecessors made a judgment as to the use at that time, the nursing home. Your predecessors made a judgment about the effects, if any, of that use on the surrounding community at that time. And you reached the judgment that the application, your predecessors reached the judgment that this application satisfied section 158.133G. There is no way in the world 33 years can go by and you can say a new use, a totally different type of use with different numbers of people, where the use has changed, where the footprint of the building has changed, where the community has changed. There's no way you can find that this use can step into the use that was approved 33 years ago. So to summarize, we assert and will argue, and I believe it doesn't require any any evidentiary testimony, we assert that this residential drug rehab facility is not a nursing home, that the only fair reading of the zoning ordinance dictates that result, that when you look at the greater statewide regulatory regime, you'll see that there's separate regulatory models for nursing homes and for drug rehab facilities. And then finally, you can't, 33 years after the fact, substitute a new use into a use that was approved by your predecessors for a different use. So for all those reasons, we're going to ask the board at the appropriate time to disapprove the application. Thank you.
Okay. With that, Ms. Miller, are you ready to call your first witness?
I am. Thank you, Mr. Bale. I would first call Mr. Robbie Stempler, who's present and seated to my left. Mr. Stempler, can you please introduce yourself to the board, stating your name and address and spelling your last name?
Yes,
Wait a
thank
minute,
you.
Wait a minute, wait a minute.
Oh, yes. Oath.
I did not do the oath. Okay, so anyone that intends to testify here today, I need you to stand and raise your right hand.
I propose, may I just address everyone who might testify, stand up and raise your hand, and you may not do it, but this is your time to be sworn in, just to say that. But we're not going to call all these people. Promise.
It's free.
Okay, I don't see any more popping up. Raise your right hand, please. Do you affirm or swear under the penalties of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
Very good. You can be seated. Okay, sorry, Ms. Miller.
That's okay. I appreciate that catch. I would call Mr. Robbie Stempler. Mr. Stempler, can you please introduce yourself, stating your name and address and spelling your last name?
Yes, thank you. Robbie Stempler, Stempler, 400 Redland Court, Owings Mills, Maryland, 21117.
And can you briefly tell the board about yourself and your background?
Sure, I've been in this space of addiction treatment for over 10 years, initially developing an electronic medical record software that ran addiction treatment centers, built that company for 4 to 5 years, operating over 2,000 facilities around the country. Opened my first drug and alcohol inpatient rehab facility about a little over 7 years ago, and moved back to Baltimore a couple years ago to build treatment here because it's needed in this state, and Maryland needs this badly.
And do you currently own this property?
I have it under contract.
Okay. Is it the intent of your entity to partner with LifeBridge in the future use of this property?
Yes.
In exploring this property, did you become aware of the previous BZA decisions that you've heard discussed at the introduction of this case?
I have, yes.
I believe that those decisions were attached to the application itself, but I've brought copies as well, and I've provided Mr. Nelson with a copy.
Very much.
Mr. Stempler, I'm showing you copies of BZA, former BZA cases 3441 and 2782. Is that accurate?
Yes.
I've marked these as applicants Exhibit 1. Like I said, I believe they're in the file, but just out of an abundance of caution, I would ask that these be entered.
And we'll accept those into evidence.
Mr. Stempler, are you aware of whether this property has been developed under these BZA approvals?
Yes.
Has it?
Yes.
To your knowledge, is there an approved site plan for the property?
Yes.
Is that what was included in the BZA application?
Yes.
Are you aware of whether this facility is used as a traditional nursing home today?
I am, yes.
Is it?
Yes. Well, not occupied.
It's not occupied
Yeah.
currently,
Correct.
but was it historically used as a nursing home?
It was.
Okay. Are you aware of approximately how long it hasn't been occupied as a traditional nursing home?
I think a year.
I'm sorry, I didn't hear the answer.
I think a year.
As part of your request, are you proposing any new development of the site?
No,
Do you intend to change anything about the access or the building on the site?
no.
Mr. Stempler, I'm showing you what I've marked as applicant's exhibit 2. I've also provided a copy of this to Mr. Nelson. Mr. Stempler, let's just walk through the pages of what's been marked as applicant's exhibit 2. Can you tell us what that first photograph is of?
Picture of the building?
Okay. Is that the front of the building?
Yes.
Okay. Photograph number 2, page 2 of 6. What is that photograph of?
The street off?
Okay, so the access to the
Yes.
site, is that accurate? Okay. Page 3 of 6, can you tell us what that is?
An entrance off the parking lot?
Okay. So that's the side of the building,
Yep.
correct? Okay. Page 4 of 6,
Parking lot?
is that the rear, can you tell us, is that the rear or the front of the site?
Rear.
Page 5 of 6,
Parking lot again?
and is that structure in that photograph the building?
Yes.
Okay. And then finally, page 6 of 6.
Another part of the parking lot?
Is that the side view of the building?
Yes.
Okay. So this is it fair to say that these photos accurately represent the property as it sits today?
Yes.
I would like to ask that these be entered as applicant's exhibit 2.
We will accept those into evidence.
It's a lot of papers. I'm just going to try to keep myself organized. Sorry. Mr. Stempler, are you aware that the term nursing home is a defined term in the county code?
I am.
Have you had the opportunity to review that definition?
I have.
In fact, do you have that sitting right in front of you?
I do.
Okay. And having read that definition, well, first, before I get to that question, we'll talk about your use. Can you explain to the board your requested use?
Yes, we are a residential addiction treatment center. Maryland states these facilities follow ASAM guidelines, so this would be a 3.5 ASAM guideline facility, providing the care under what ASAM defines as 3.5 residential. That would include
I'm going to cut you off really quick. Can
Okay.
you tell everybody what ASAM is?
the addiction, I'm going to mess this up, Addiction Science Society of, I'm missing the word, American Society of Addiction Medicine.
Thank you. Sorry, I didn't want to cut off your train of thought, but I don't think that that's a widely recognized acronym for most of us. So, continue.
Sorry, yes. So in layman's terms, it's kind of summed up as 24-hour care, providing medical and clinical services for clients that are suffering with substance abuse and/or alcohol and mental health issues.
Are you aware of whether the state has a licensing requirement to operate a traditional nursing home model?
Yes,
Are there state laws pertaining to that licensing?
yes.
What are those state laws, if
Objection.
you're aware?
Here we have a lay witness expressing opinions about nursing homes and what the law requires, so I object in 2 reasons. First, it requires expert testimony. 2, it's a legal question.
Ms. Miller,
I'm not asking him, I'm not going to ask him to interpret any of this. I'm purely going to ask him what section, he does have knowledge of this, and I'm going to ask him what section of the code regulates nursing homes. I'm not going to ask him to interpret or posture anything that
Okay,
that's
we'll-
not in his
we'll
area of
allow that
expertise. Thank you.
Under that context.
Thank you. Mr. Stempler, what state laws pertain to nursing homes?
I know that Comar
Okay.
regulates.
Okay. Are you aware of what title in Comar regulates nursing homes?
I am. I can't think of the numbers off the top of my head, but
Title 10?
10.
Go ahead.
I'm sorry,
Mr.
that
Nelson.
was not a legal point I just made, but because I was stunned. Object to the leading question.
Okay, and I'd just like to direct if you don't know the answer to the question, just state that, okay?
Got it.
Changing gears. Are there state licensing requirements for the type of residential treatment facility that you're proposing?
Yes.
Okay. Are there laws pertaining to that licensing?
Yes.
Who regulates that?
Comar. So that's it.
Are you aware of whether it's the same or a different section of Comar that regulates nursing homes and residential treatment facilities?
It's the same.
Objection.
And
Same objection. These are legal arguments, legal questions being addressed by a lay witness.
Mr. Bale, I'm presenting this evidence not for my client to analyze the legal sections of the code, but to point out that both are regulated by the exact same titles, chapters of these agencies. I'm not going to ask him to interpret or make a legal conclusion on what they say.
okay, I'll allow that as long as you don't do that. You're only asking of you're not asking a legal interpretation of the code. Okay.
Correct, I am not. Mr. Stempler, is it accurate that there are different levels of residential service?
Yes.
Who recognizes those?
ASAM, which is what the state of Maryland follows.
Is ASAM a national or local agency?
National.
Thank you.
Mr. Stempler, you're looking at what I've marked as Applicant's Exhibit 3. And Mr. Nelson, this is the ASAM and CARF article that I've provided a copy of previously. Can you briefly summarize what this says?
Yeah, it goes through the description of the different levels of care per ASAM and the guidelines, and as of about a year ago, they did a partnership with CARF. The state of Maryland requires that you either have a CARF or Joint Commission accreditation in order to operate these types of facilities, but that's what's
Okay.
being said.
Is there a state agency? Oh, well, first let me ask that this exhibit be entered as Applicant's Exhibit 3.
We will accept that into evidence.
Is there a state agency that regulates these levels locally aside from the ASAM guidelines that you just spoke to?
Comar.
Okay. What does COMAR stand for? Did we say this? I'm sorry if we did. Okay.
Code of something.
Okay. Can you generally walk us through the levels, and I don't want you to get too specific, but I want you to explain to the board the levels of service that are recognized by ASAM and that are governed by COMAR.
Okay. Pertaining to this, I'm just going to go through 3.0 to 4.0. 4.0 and 3.7 withdrawal management is a medical level of care where you're detoxing the client. So you're physically separating the client from drugs and/or alcohol, generally speaking, 7 to 10 days. And then there's ASAM 3.1, 3.3, and 3.5, which are all considered residential care. 3.5 has minimum of 40 hours of clinical services a week. 3.5 less, 3.1 even less. It's more of a community living type guideline that ASAM created, where you only have to have 5 hours of clinical services a week.
I'm sorry, what level was that only requires 5 hours?
3.1.
Okay. And do you know what level you would operate at this facility at?
3.5.
Okay. Mr. Stempler, I'm showing you what I have marked as Applicant's Exhibit 4. Can you just tell us what this document is?
Yeah, it's describing level 3.5 ASAM level of care.
And this is the level that you propose at this facility, correct?
Correct.
Is this a document that you prepared, or that is kind of a state document?
State, I didn't prepare this.
Okay. I would ask that Applicant's Exhibit 4 be entered.
We'll accept that into evidence.
Mr. Stempler, do patients stay overnight at this type of facility?
Yes.
Is there an average period of stay for a patient at this at a 3.5 level facility?
Yes, generally 30 to 45 days.
As part of the level of care and your proposed use at this facility, are you proposing any planned outdoor activity?
No.
Are there any, does this use generate any noise, odors, or dust greater than what you're aware existed previously?
No.
Can you describe the staffing at a facility like this?
Yes, 24-hour staff. Clients are monitored and mechanisms such as rounds every hour done where you're locating where the clients are. There's a full clinical team that's providing licensed clinicians to do more of the therapeutic side. And then there is a full nursing and medical team to help provide the medical care that's needed post-detoxification. So generally speaking, usually clients are on some, meds that are helping them with depression and or anxiety, non-narcotic meds. So that's, continued post-detox.
Approximately how many total employees do you think you would need for a facility like this?
Around 60
Is that total or is that per shift?
total.
Okay. So how many shifts are there?
3 shifts.
Okay. And you said that there's 24-hour staffing. Is that 24-hour clinical staffing at this type of facility?
It's 24-hour staffing. There is one member of the clinical team that's there always 24 hours.
Okay. And is this all part of your licensing requirement to operate a facility like this?
Yes.
Can you compare the traffic associated with this use as to what existed previously on the site?
Objection.
It'll be,
I'll rephrase. Are
Thank you.
patients allowed to have cars on the site?
no.
How do they get to and from the site?
They're either dropped off or transportation is scheduled.
Would that all occur during normal business hours?
Yes.
And what about employees? How do they get to and from the site?
Drive.
Okay. Are there any visitors allowed?
Yes, but that's not prior scheduled and clinically planned, and you cannot just show up and visit. I would say less traffic.
Are the visitors during controlled hours?
Oh, yes, yes,
Are those all during normal business hours?
yes.
Have you had the opportunity to review the normal dictionary definitions of chronically, the term chronically or chronic?
I have.
You again?
Mr. Stempler, you have in front of you what I've marked as applicant's exhibit 5. Is that the dictionary definition of chronic?
It is.
Okay. Can you read to us what that says?
A continuing or occurring again and again for a long time. Suffering from a chronic disease, always present or encountered.
Sorry, I'm going to be doing a lot of walking.
Thank you.
Mr. Stempler, I'm now showing you what I've marked as applicant's exhibit 6. Can you tell us what that is?
The definition of convalesce?
Can you read that to us?
Sure. To recover health and strength gradually after sickness or weakness.
I'd like to ask that both exhibits 5 and 6 be entered.
We will accept those into evidence.
Mr. Stempler, in reading those dictionary definitions, how does that describe the type of facility that you operate?
Objection to, I have no objection to the introduction of the definition. I have no objection to the witness reading the definition, but I do object to him expressing an opinion as to whether the proposed use meets one of these definitions.
I'll attempt to rephrase and see if that's...
Okay, please.
Mr. Stempler, I'm looking at applicant's exhibit 5, the definition of chronic.
Mhm.
It reads, continuing or occurring again and again for a long time. Does that accurately depict the type of addiction that your patients suffer from?
Objection.
Yeah.
What's
It's
the
been,
objection?
Hold on, just wait until they...
This is a legal opinion rendered by a lay witness on an issue that the board needs to address at the conclusion of this case. I just don't think that a lay witness should be permitted to provide legal interpretations of whether his use meets a certain definition. That's the basis of the objection.
Ms. Miller?
This is a general Merriam-Webster definition, and I think my client is more than suited to answer the question of whether his type of facility serves somebody suffering from a chronic condition. He has explained his experience in the industry and his other establishments that he has, and I think he can accurately describe the type of patient that he serves.
I'm going to allow the question and allow you to answer the question under the context that it is not, the context is it's based on his experience and the clients that he's dealing with, not the legal definition in the county code. So I will allow that.
Thank you. Do you need me to restate the question, Mr. Stempler?
No, yes, addiction is a chronic illness.
Looking at what I've marked as applicant's exhibit 6, convalesce, reads to recover health and strength gradually after sickness or weakness. Can you speak to whether that's something that your facility promotes?
Exactly what we do.
In your industry, is alcoholism and/or drug addiction recognized as a chronic illness?
Yes,
Have you had the opportunity to review the dictionary definition of addiction?
I have.
Thank you.
Mr. Stempler, I'm showing you what I've marked as applicant's exhibit 7. Can you tell us what that is?
The definition of addiction by Merriam-Webster.
Okay. And can you read that to us?
A compulsive, chronic, physiological, or psychological need for a habit-forming substance, behavior, or activity having harmful physical, psychological, or social efforts and typically causing well-defined symptoms such as anxiety, irritability, tremors, or nausea upon withdrawal or abstinence, the state of being addicted.
Having reviewed these definitions, these dictionary definitions, and your familiarity or reading of the county code definition, do you believe that your use falls within the use allowed as a nursing home?
Objection.
Could you restate the question? You're asking his expertise as it relates to the definitions. I'm okay with that, but as far as the code goes, he hasn't been pre-qualified as understanding the codes.
I may need to rephrase, Mr. Bale, because what I'm trying to ask is, knowing these general definitions that we've just read from Merriam-Webster, applying those are the terms used in the code definition that are not defined by the code. So in reading those general definitions, does he believe those general definitions meet his use requested?
Okay,
That
and
more-
that's different than
Okay.
what you.
I will re-clarify by saying it that way.
And I have no problem with that questioning.
Thank you.
Yes.
Those are my only questions of Mr. Stempler.
Okay, Mr. Nelson, do you have questions of Mr. Stempler's testimony?
I do, thank you. I won't be long. Mr. Stempler, do you have a copy of Exhibit 2, your work copy that you could look?
Yes.
So these, the packet of photographs, I think there's 6. I just have a few questions. Mr. Stempler, page 1 of 6, what building is this?
The building we're talking about?
Which part of the building we're talking about?
Didn't we already go over this?
Just answer the question. He did answer this question in my testimony. We walked through the location of each photograph, but
I'm just
Can
asking,
you,
tell us what this
There.
building is.
What this building?
What does that
I don't
show?
know,
what does that photograph show?
Oh, pardon me, Mr. Chairman, I'm asking my cross-examination. I would prefer it if counsel wouldn't.
I apologize.
Right. My
Mr.
question is,
Nelson.
what does Exhibit 1, photograph 1 of 6 and Exhibit 2 depict? That's the question for the witness.
the building that we're in discussion about.
All right. So is this the entire building or just part of the building that we're talking about?
Part of the buildings in the
All right.
photograph.
Now, let's go to page 2 of 6, please. I see an asphalt driveway, and I also see a structure Is that structure part of what we're talking about in this case?
I don't know what structure you're referring to.
I would ask the board to look at page 2 of 6, and I'm directing the witness to a structure in the photograph, a building. My question to the witness is that building part of this application?
Yes.
I beg your pardon? I didn't hear you.
Can you point? Are we looking at the same?
Page 2 of 6, Exhibit 2. The building that we're all looking at together, is that part of this application?
If I'm looking at the same thing as you, yes.
Okay. All right. So just so now just approach the witness. You're at page 2 of 6. So I'm going to put a circle around that building on my copy, and that's the building I'm referring to. So the record, your testimony, sir, is that building is part of this application?
My understanding, yes.
All right. I'd like to move into evidence my copy of Exhibit 2, page 2 of 6, which circled that building. Sorry, I only have one copy of this, Mr. Chairman.
That's okay.
That's fine.
Mr. Nelson, you want to move that into evidence?
Yes, sir.
Okay, we'll accept that as evidence.
Now, Mr. Sempler, is it your testimony that there have been no changes to this nursing home since the year 1990?
I do not know that, no.
How many employees were there in the year 1990 at the nursing home when this conditional use was approved 33 years ago?
I do not know that.
Now, I want to ask a few questions, if I might, sir, about the different levels. You referred to 3.1, 3.5, 3.7, and 4.0, I believe.
Correct, ASAM?
And I understood you to communicate, and I'm doing this from memory, so I'm not trying to put words in your mouth, so correct me if my memory is flawed. But 3.7 and 4.0 are the most extreme. That's where you're doing withdrawal treatment, where you're trying to, is that the message you communicated?
Yes, it's considered as detoxification in
All right.
the industry.
So the 3.5 is one step down from that. That's for high-intensity residential services, isn't it?
Correct.
And the 3.5 level for high-intensity residential services is more intense than level 3.3.
You could say that.
Well,
Define intense, less clinical
all right,
hours.
well then, this is your area, not mine. What's the difference between 3.7, correction, between 3.5 and 3.3?
Less required clinical hours.
Okay. And in layman's terms, can a layman draw from that the patients who are being treated at a 3.3 level don't have it as an acute a need for treatment as the patients at the 3.5 level?
Yes, but private insurance doesn't even acknowledge 3.3 or 3.1 as a level of care. It's just residential 3.5.
All right. And 3.1 has less clinical care than 3.5, is that right?
That's correct.
All right. And what you're asking this board to approve is level 3. What you're asking this board to approve today is level 3.5 with 60 employees.
Correct.
That's all I have. Thank you.
Okay. This is going to be fun. Anyone in the audience have any questions?
Who's not my client?
Right.
He's not his client.
Who's not his client?
Yes, I'm sorry. I understand what you're saying. anyone that is not Mr. Nelson's client that's in the audience, if they have questions of Mr. Stempler's testimony, and again, only questions of his testimony, your own testimony will be allowed at a later point in the proceedings, I promise you. So anyone who has a question of his testimony, go to the microphone. Go to the microphone. And please state your name.
Nick Hershan,
Okay, state your name, address, occupation, and spell for the record your last name.
Nick Hershan, 1607 Glenwood Court, Finksburg, Maryland, retired.
And how do you spell your last name?
Hershan.
Okay, thank you.
I have a question. You stated earlier you have a contract for the building. Do you have any stipulations?
Objection. He did not testify to the specifics of the contract. I don't think it's really relevant to this proceeding.
Yeah, he just said that he's a contract purchaser, so,
Well, and I will point out that LifeBridge Health, who owns the property, did also sign the application as the property owner, consenting to this application as well.
What were there stipulations in reference if you don't get approved?
that's, the relevancy of that has nothing to do with our decision-making here, so.
Okay.
Anyone else have any questions of his testimony now? Okay. Wait a minute.
Yes, my name is David Ader, 5241 Stonebridge Way, ADER, and I'm retired. So under 3.5 treatment, is that court-ordered treatment or is that voluntary admission?
Voluntary.
And so if somebody is voluntarily admitted, they leave at any time.
Correct.
Sign themselves out at any
Correct.
time, in the middle of the night,
Correct.
any time during the day.
It's not jail. They are free to go, but there's a discharge process, so they don't just walk, they can't just walk off property.
So clinically treated at a serious level, they could sign out at any time without transportation and walk in the neighborhood,
No, they would have to follow the discharge process.
but if they don't want to.
It's not jail. I can't lock them in.
I have no other questions.
Okay, any other questions of his testimony? Name,
Can I-
address, occupation, and spell for the record your last name, please.
Richard Lawson, 5087 Amantea Way, retired, LAWSON. I just had a question about the number of employees. How many of those include security employees? So is that facility is not secure?
It is secure. There is.
I've been by it.
Oh, I thought you meant if I'm operating it. What would?
Well, yes. How many will be security?
So, security people are, I don't think I would use that term. I think this is kind of a big issue that addiction is viewed as criminals, and that's not the case. So as far as like security, I would say that my facilities are extremely secure. I've never had anyone walk off premise on my existing facilities. I've never had anyone die. I've never had, any altercations that are physical, anything like that. And, there's 24-hour care, so I don't know. When you say security, I'm envisioning, jails and people with badges and guns or weapons. That's not going to be the case.
So could we say that the answer to that question is none of the employees are dealing with security?
Define security.
Well, someone to be checking the doorway to make sure that person isn't leaving without proper discharge papers.
Oh, yeah, there are definitely employees.
Are they considered security employees?
Yes, there are definitely employees that are obligated and responsible for doing that.
Oh, if you say so. I'm done.
If I say,
Yes, they're in the back. Go to the microphone. Name, address, occupation, and spell for the record your last name.
My name is Matthew Pollack, Pollack, career firefighter, local business owner. So, Mr. Stempler,
Mr. Chair, just briefly, I'm sorry, I hate to cut anybody off, but I have to object because I think a few of the people that have been cross-examining are on Mr. Nelson's list of clients that he's provided me. And so I believe we clarified as a point of order that under this board's rules of procedure, they cross-examine through their attorney.
So I'll ask you the question.
no, sir, I'm not.
You are not?
I'm not
Okay.
representing.
I'm sorry, I didn't ask that question of anyone that previously went to the microphone. Okay, go ahead, Mr. Pollock.
Mr. Stempler, thank you for giving us a better idea of what you do. It's now pretty clear to me that by your testimony, these people are free to come and go. Is that correct?
Yes.
Okay. Now, I have a pretty good understanding of dealing with people with substance abuse in my line of work. What I've noticed in the past, and I'm going to ask you, do the people who are coming to your facility, court-ordered, not court-ordered, free to come and go, do they frequently have criminal histories?
I wouldn't say frequently.
Do they at all?
I've had clients that have had criminal histories.
Okay. Have you ever had drugs introduced into your facility when someone leaves and comes back? Has anyone ever tried to bring drugs back to your facility?
Of course, clients have tried.
Okay. Do you or have you ever had anybody at any of your facilities who is a registered sex offender?
We're not, I can't answer that. We don't.
I believe there's a requirement when someone has an address, in this case, they'd be changing their address temporarily, that they would have to register.
They don't have to change their address.
My understanding of the registered sex offender, if I was, and
Oh,
I'm
if
not,
you're-
a registered sex offender, I'm going to go spend 50 days at a facility. I need to notify the local authorities and people in the surrounding area that I was a sex offender.
Apologies, I thought you meant all clients would have to change their addresses, the permanent residence.
So is it believable or understandable that you could have a registered sex offender being introduced into this neighborhood without the residents knowing?
Yes.
Okay, thank you. Is it my understanding that we could have people with violent criminal pasts staying in our neighborhood around our children who would not have been there if this facility did not exist?
Objection.
Okay, let me phrase it this way. If this is a nursing home, do you think that we're getting people who have convictions, violent criminal histories, sex offenses, staying at a nursing home?
Yes.
Objection. Mr. Nelson specifically pointed out that my client is not here testifying as an expert in the nursing home industry. So I think he can offer a layman's opinion on that. I do not think that he can
You need to
offer an
rephrase the
industry
question.
Okay.
expert opinion.
Do you do a background check on the individuals who are staying in your facility?
No. Background check, not as the same as I would background check an employee. We do a pre-admission assessment. We have an extensive pre-assessment done post that. I guess when you say background check, I'm thinking of how I would perform a background check from an HR perspective for an employee. But yes, there is a background process that we would call pre-admission and are going through questions such as past use, past treatment, past legal issues if there are, family members, previous diagnoses, so on and so forth.
Okay. As an expert in the addiction field, do you see a correlation at all with addiction and criminal history?
No.
So it is your testimony that a addict, a chronic addict, as you eloquently read us the definition of, has no greater chance of having a criminal history than the average person walking through the streets of Carroll County.
I'm a chronic addict and I don't have a criminal history.
Well, if you're an addict, drugs aren't legal.
Wait a minute. That's enough out of the gallery. Unless you're at the microphone, identify yourself, keep your comments to yourself. Thank you.
So it is your testimony today that the addicts at your facility have no greater chance of breaking other laws in the community than the average citizen living on Buckhorn Road.
Objection. I don't know, I mean,
That's a hypothetical
it's
question.
just too hypothetical.
I'm sorry, it's,
He's a proclaimed expert in this area. I can tell you as a career firefighter.
I mean, that's testimony. You have the opportunity to do that later.
Sir, I'm not giving you
Questions-
testimony.
Questions only of his testimony.
Have you ever had any violent incidents at any of the facilities, the thousands of facilities that I heard you say you were associated with?
I think you're speaking from a software perspective, not my own personal facilities. Is that what you're asking?
From any of your facilities, have there ever been an issue with violence?
Nope.
Not one incident of violence at any of those?
N-O, no.
Okay. But you said there have been drugs introduced into those facilities, correct?
I said that clients have tried to admit with drugs. Yes.
So with that reasoning, with your facility in our neighborhood, we can expect additional influx of drugs
Objection, this is
into
testimony.
the...
Again, that's testimony. You're supposed to be asking questions. I'm putting you on a short leash.
That's fine, sir. Do you believe that there is any safety concern whatsoever with putting this facility in the middle of a residential neighborhood adjacent to a park?
No, we view these facilities different. All my other facilities are in residentially zoned houses.
No further questions.
Thank you. Any other questions of his testimony? And again, I'm going to ask you as you go to the microphone, are you one of Mr. Nelson's clients? Okay.
Hi, I'm Justin Grove. I live at 5272 Freder Road.
Could you speak up, please?
Sorry. My name is Justin Grove, Grove. I live at 5272 Freder Road. I'm a satellite ground system engineer. I just wanted to clarify, what is the timeline for treatment? I thought I heard 15 days and then maybe up to 50. Is that clarified in the level of care of the 3.5?
No, I mean, we treat, I would say the average length of stay is 30 to 45 days. The inpatient residential model, sometimes it's referred as like the Betty Ford model, is 30 days. But you're working with the insurance providers and staff to determine the length of stay individually per each client. But on average, it'll be 30 to 45 days.
Okay, and just one final question. For the zoning part, are any other facilities in agriculture zoned areas like this one is proposed to be?
Not mine. I don't
If you don't know.
know. I don't
you
know.
don't know.
Yeah, I don't know.
Say you don't know.
I don't know.
Okay, thank you. No further-
Thank you. Anyone else have any questions of testimony? And again, I'm going to ask you as you come to the microphone, you're not one of Mr. Nelson's clients.
I am. My name is Ben White.
Okay, wait a minute. You're one of Mr. Nelson's
Oh,
clients?
yes.
Okay,
You don't
your
get-
questions can only be addressed through your attorney,
Oh, okay.
okay? Thank you. Anyone else have any questions? I'll ask you the same question as you. Okay, very good.
Jeff Bejune, Bejune, 1306 Buckhorn Road. I'm a government property manager. Just a couple quick questions. I think most of my questions were answered previously, but are you a profit entity?
Yes.
All right. And two, I know we spoke about criminal history. Do a lot of your clients have mental health issues?
So if they are mental health primary, we won't treat them. Co-occurring happens often with addiction, but we are not primary mental health.
All right. But a lot of your clients do have mental health issues.
Yeah, I don't really.
I mean, you're just saying they have both, and that's what you can treat.
Correct, but we cannot
Thank you.
treat
Thank you for
primary
your
mental
comments.
health.
Any other questions?
They would have to have primary substance abuse.
Okay, board members, questions of the testimony?
Wow.
Sure.
I do.
Mr. Snyder.
So if I understand correctly, your industry, the residential drug treatment industry, which I'm not overly familiar with, is managed through COMAR regulations. Is that correct?
In Maryland, correct.
In Maryland. And who's the governing agency of COMAR in Maryland?
The Department of, I don't know. It's not the health department.
I'm asking you.
I don't know.
Have you ever managed or operated a owned or managed a drug treatment facility in Maryland?
So I have a $13 million ground-up build in Baltimore County that has a certificate of need for
Is it
detox.
operational or is it just being developed?
It's being built as we speak.
So is the
And-
answer that you've not operated a facility in Maryland?
Correct.
Okay.
Not directly under Hygieia, correct. Yep.
So
Yep, yep, yep.
When you talk about staffing and dealing, I'm relatively familiar with nursing homes, having a wife that's been in the industry for years. Are any of the facilities you worked in been is it ASAM or
ASAM.
What
Yeah.
was the emphasis?
ASAM.
ASAM. Thank you. ASAM are COMAR certified? I'm not COMAR, but CARF certified?
What was the question? I'm
Is
sorry.
either of the facilities or any of the facilities that you've been involved with or managed been certified by CARF
Yes,
or by, okay.
and Joint Commission.
And where were those facilities?
California.
Okay. And when you talk about staffing levels, is this COMAR, I know the nursing home industry, the staffing levels are very regulated. You must have A, B, and C. X amount of RNs, X amount of this, X amount of that. How is that, how is staffing at residential drug treatment, abuse, whatever the word is?
Same.
Recovery, yeah, how are they managed?
Same where there's a client per ratio of client per therapist, client per nurse.
And that includes the skill set, the particular skill sets?
Correct.
Okay, and is part of the skill sets that you require, given the type of facility that you're asking for, require a certain medical requirement, like an RN must be on site all the time, or whatever the case may be?
Correct.
Okay. And lastly, if I can understand, how long has this facility been not occupied?
My understanding is a year, around a year.
1 year? So in the last year, it's been used as a nursing home or some type of activity like that? Is that what I'm not looking, I'm looking at you. Is that what you said?
Yes, my understanding is
Okay.
within the last year, but it's been about a year.
Got you. That's my questions.
Any other questions of his testimony, board members?
One other
Ms. Ecker.
quick follow-up question, the questions you asked. So, private insurance, is that how, assuming that, say I need to go to your facility and I have private insurance, is the coverage or the treatment typically covered by private insurance, like it would be if I went to the hospital or some other?
Correct. But
Facility.
we will accept private insurance, Medicaid, all the payers.
Thank you.
Any, no follow-up questions, Mr. Nelson?
Nothing further.
Ms. Miller, any follow-up questions while he's,
I do have a few, Mr. Chair, just to clarify a few things that were asked of him. Mr. Stempler, Mr. Ader, I believe, I'm going to try to pronounce everyone's last name correctly. Mr. Ader asked you about the voluntary discharge process. Can you just go into a little bit more detail about what it requires to voluntarily discharge?
Correct. So when a client admits, we're taking all their valuables, their money if they have any, their phone, their ID, their wallet. So when they are choosing to discharge AMA or against medical advice or involuntary or voluntary, they would have to go through a whole process of signing the documents, getting back their valuables, their receivables. I've never had a client walk off premise.
Mr. Lawson asked you about the security at this facility in terms of employment. Can you explain what security will be present?
Yeah.
Not necessarily in terms of a person, but like what are your security measures here overall?
Cameras everywhere, not, one door in and out. We cannot lock the door, but one door in and out, 24-hour staff monitoring through the electronic medical record system. We're doing rounds, so every hour, checking where the client is, sometimes even Q15 every 15 minutes, and then noting in the medical record where that client is physically, having eyes on him or her.
You were asked by Mr. Bajoun whether this is a for-profit entity. Does that impact in any way, shape, or form how you operate this facility?
No.
Describe some of you spoke to Mr. Bajoun's question about mental health issues, and you said that you will treat when it's co-occurring. Can you just provide an example of what that would mean or what that would look like?
Yeah, I mean, I have not, in my decade-plus experience in this field, have not met someone that is addicted to drugs and alcohol that didn't suffer from depression, anxiety, or some sort of mental health issue. So that's what co-occurring means. If they are schizophrenic, which is mental health, or let's say bipolar 2, like that would be more of a Shepherd Pratt mental health primary facility. We wouldn't be treating them. They would, have primary substance use disorder, and I don't think you can have that without having some kind of mental health issue.
Those are my only follow-up questions. Thank you.
Mr. Nelson, based on that, do you have any further questions?
Nothing further, thank you.
Okay. At this point, we're going to take about a 5 to 10 minute break.
Thank you.
Reschedule?
Okay, we're going to call the BZA back to order. Ms. Miller, do you have another witness?
I do, Mr. Chair. I would next call Mr. Jay Voigt. Mr. Voigt, I see that you're seated at the podium already. Can you please introduce yourself, stating your name, spelling your last name, and your address for the record?
My name is Jay Voigt. It's spelled V as in Victor, O-I-G-H-T. I am the county zoning administrator, and I work here at 225 North Center Street.
In your capacity as the zoning administrator, what do you have authority to do?
Enforce and interpret the code of the zoning ordinance.
And are you aware that there is a definition of nursing home?
I am.
There was a letter that was introduced as part of the file at the beginning of this case. I don't know if you need to see a copy, but can you say whether that was an accurate, whether that contains your signature or not? Sorry, it's the second page.
That is my signature, and it is, I do agree with that interpretation.
In considering the characteristics presented, do you believe that this use meets the definition of a nursing home, the county code definition of a nursing home?
Objection.
I do.
And the objection is?
There's been no voir dire. There's been no proffer of expertise. There's been no acceptance of the witness as an expert. And the attorney just asked an opinion question. That's one of the bases of the objection.
You want to qualify?
I will back up, and I'm aware that Mr. Voigt has appeared several times in front of this board as an expert in the area of zoning. If you'd like me to actually ask him the qualifying questions, I'm happy to, but because of his past testimony, if you're willing to, I would ask that you accept him as an expert in the area of zoning.
And we will. Mr. Voigt is almost a monthly guest of ours.
Thank you. Mr. Voigt, I'll re-ask the question. In considering the characteristics, do you believe that the proposed use meets the county code definition of a nursing home?
I do.
Do you have the county code in front of you, Mr. Voigt?
Yes, I do.
Why do you believe that it meets the definition of a nursing home?
Our definition of a nursing home reads as a residential health care facility which provides institutional lodging, nursing care, personal care, and supervision to aged, chronically ill, physically infirm, or convalescent patients who are not related to the owner or administrator of the facility.
Mr. Voigt, as part of your duties, your official duties as zoning administrator, do you interpret and enforce previous BZA decisions?
I do.
Do BZA approvals run with the property?
They do.
Do they expire?
No, they do not.
Are there other uses in our code that are not specifically carved out but that are allowed in the county?
Yes, there is.
Can you provide an example or two?
Most people would not consider a methadone clinic, which is a drug treatment facility. The county considers that as a doctor's office, as a medical office. It's where patients are being treated by a physician or qualified staff.
And in making that determination, you look at the characteristics of the use. Is that accurate?
That's correct.
Okay. Is there also a general use of general retail in our county code?
There is.
Is that similar in nature, whereby you have to assess the characteristics of a use and apply that definition to decide whether it meets?
I do.
Those are my only questions of Mr. Voigt.
Mr. Nelson, do you have questions of Mr. Voigt?
I do.
Okay.
Mr. Voigt, you've been the zoning administrator here for how many years, sir?
13 years.
All right. So since about the year 2000.
2010.
2010, I'm sorry, I lost a decade there.
We all did.
But my point is, you weren't the zoning administrator in 1990.
That's correct.
All right. Now, do you have the, I understand your testimony in layman's terms to be, in essence, this proposed application meets the definition of the county's definition of nursing home.
Yes, it does.
All right, and you have your definition there, do you not?
Yes, I do.
So let's go through that together. Nursing home in bold font, period. First phrase is a residential healthcare facility which provides institutional lodging. Residential healthcare. Now, it's fair to say that in most nursing homes, the period of residence is longer than 45 days.
Objection? Mr. Nelson, I'm not sure if that's testimony or if there
It's
was
a
any.
question. The question
I'm
is, would he not agree that most residents in a nursing home are present there in that nursing home for more than 45 days? That's
Not
the question.
necessarily.
Give me an example of a resident who's been in a resident, who was alive and remained in a nursing home less than 45 days.
I broke my leg severely 4 years ago,
Mm-hmm.
and after I got out of the hospital for a week, I was sent to a nursing home for rehab, and I was in that facility for 3.5 weeks.
All right. So what you're saying is a nursing home, in your judgment, includes a rehab facility.
That's correct.
All right. Now, would you also agree that a nursing home provides nursing care? That's one of the key ingredients, key elements, nursing care.
What's your definition of nursing care? And
My question to you, Mr. Voigt, is do I see the two words in this definition, quote, nursing care? Are they present in the definition?
yes, they are.
Okay. Describe for me the nursing care present in this drug rehab facility, level 3.5.
I have not been told what the level of nursing care the applicant provides to his clients.
All right, so just so the record is clear, you and I are agreeing right now that you have no knowledge as to what, if any, nursing care the applicant would provide at the proposed drug rehab facility.
I don't know the level of nursing care he's provided. I haven't been briefed on what it is. My understanding of nursing care is basically someone who is assisting someone who needs help in very difficult times.
How many nurses will be there?
I have no idea.
All right. Now, let's go to the next line. Supervision to, what's the next word?
Well, but we were personal care and supervision to the aged.
To what?
To the aged.
To aged. Now, as your role as zoning administrator, how do you interpret that word, aged?
Anyone born between being born and whenever they die. I mean,
Wait a minute. Called you down before, I'm gonna call you down again, and I'll clear the room if I have to. This is his testimony under oath. Respect it.
Question,
ahead.
sir, is how do you, what does the word in this definition, aged, mean? Does that mean a young adolescent in high school who's addicted to drugs?
I would generally say no, but like I say, there's no limit to what you would refer to as aged.
Okay. But you would agree that most people reading this definition, when they see the phrase aged, they would think, when it's in the context of a nursing home, elderly person, would they not?
Elderly? I don't think I would say elderly.
All right. How about an 18-year-old boy who has the misfortune of being addicted to drugs? Would he be, in your parlance, an aged patient?
Not necessarily, no.
Come on, please. Mr. Voigt, in your role as zoning administrator, can you give me one example of another case where an applicant has petitioned the Board of Zoning Appeals in Carroll County to say there's a prior approval of a nursing home, conditional use, and we want to step into its shoes with a drug rehab facility?
Well, I wouldn't say necessarily that, but like I say, as far as I'm concerned, a drug rehab facility
What the
would
question,
fall under
sir? My
nursing.
question, pardon me, was very precise. Can you share with this board, based on your years of experience in this county, one example where an applicant has petitioned prior to this case, petitioned the Board of Zoning Appeals to say, we have a 33-year-old approval for a conditional use, and we want to step into that approval with a drug rehab facility? Conditional use for a nursing home.
I can't think any of, right at the moment, I don't have all the case files in front of me to say whether there was or not.
So you don't know? You can't
I
give us an
can't
example.
recall any.
Right, that's all I have, thank you.
Ms. Miller, do you have any cross?
I have a few follow-up questions for
Follow-ups.
Mr. Voigt, if you will. Mr. Voigt, I'm looking at the definition of nursing home, and I just want to read through it again. So, Mr. Nelson just directed you to the part that said aged. Can you read the full definition for us first?
A residential healthcare facility which provides institutional lodging, nursing care, personal care and supervision to aged, chronically ill, physically infirm, or convalescent patients who are not related to the owner or administrator of the facility.
And is the word "or" before convalescent patients?
That's correct.
So would it be your interpretation that one must meet one of those?
Now we have I object. Now this is a legal grammatical debate about what that disjunctive phrase means. It's a legal argument. It's not a subject for this witness. I asked him about the word aged. She's asked him about the word convalescent and chronic, I believe. So I would object to this question.
I'm happy to make the legal argument in my closing statement. I think Mr. Voigt just testified that his authority to interpret the zoning code. And in interpreting it, he has to look at the words or and in making his determination.
And I'm going to allow him to answer the question based on, we've qualified him as an expert witness as zoning administrator. And he's giving his opinion as zoning administrator, not as an attorney.
Can you repeat the question, please?
In your interpretation, Mr. Voigt, does one have to meet all or one of those because of the word or?
It does not have to meet all of them.
Thank you. I have one additional question. Mr. Voigt, are you aware of other residential treatment facilities in Carroll County?
Yes, I am.
So this will not be the first allowed in the county, correct?
Correct.
Those are my only questions, Mr. Voigt.
Okay, board members, questions of Mr. Voigt's testimony?
None.
Thank you very much, Mr. Voigt.
Do I get to redirect?
Yeah, I'm sorry, Mr. Nelson. Yes, if you do.
All right.
Please get my attention if you do, if you want to redirect.
Mr. Voigt, you mentioned there's another residential treatment facility in Carroll County. Can you name another residential drug treatment facility in Carroll County that's not associated with a hospital and is not on land zoned I-2?
There are quite a few residential treatment centers throughout the county in residential areas in single-family homes that are group home that are treating recovering alcoholics and drug addicts. There are quite a few. In fact, this board just had a case not too long ago where one of those facilities was asking to expand, and the board at that time turned them down.
My question, sir, is can you name a residential facility in Carroll County that's not associated with a hospital and is not an I-2 land?
Yes.
Give me one, please.
I can't remember the names of them all.
Mm-hmm. That's all I have. Thank you.
Anything further, Ms. Miller?
No, thank you.
Okay. Thank you, Mr. Voigt.
Thank you, Mr. Voigt.
You're going to call another witness?
I have one more witness, Mr. Chair.
Okay, very good.
Call Mr. Marty Hackett, please. Mr. Hackett, can you please state your name, spelling your last name, and your address for the record?
Yes, Martin Hackett, 439 East Main Street, Westminster, 21157. My last name spelled Hackett.
Mr. Dixon, may I ask, are we numbering exhibits for applicant and for opposition?
Yes.
Okay. I just wanted to make sure I get my accurate number here. Sorry.
Can I have opposition exhibit 1?
Thank you.
Mr. Hackett, as this board is aware, has appeared before this board several times as an expert witness historically. I'm more than happy if Mr. Nelson wants to ask him any additional questions. I have provided a copy of his resume to Mr. Nelson, but I would ask that because of his past experience in testifying as an expert, that this board would accept him as an expert in the area of land use, design, and planning.
Mr. Nelson, any objection?
Well, I may. I see no degrees on his CV. I mean, so yeah, I do object. I'm looking at his CV. It says continuing education at community college. It talks about traffic planning. I'm not seeing any expertise in land planning, urban design. I'm seeing engineering work at Daft McCune Walker, KCI, and CLSI. I'm not seeing land planning work. I'm not seeing a college degree. I'm not seeing a graduate degree.
Ms. Miller?
Well, Mr. Hackett has a copy of his resume in front of himself as well, and I'm happy for him to go through the projects that he's worked on, the company that he works for. So, Mr. Hackett, can you just describe who you work for, your role in that capacity, and how long you've been working there, and the projects that you've worked on in Carroll County?
Sure.
Sorry, I can repeat some. I know I just strung together a lot of questions for you to remember, so I'm happy to.
That's no problem.
Re-say them.
I'm president of CLSI. It's a local engineering, land planning, surveying, consulting firm. I've been there, June 16th will be 35 years. I started working prior to that down in the Towson area, doing from engineering design to planning. I am a land use consultant, land planner. There's really no certification for a land planner. You can be a certified planner, but and land use consultant. Over the years, I've testified in front of courts and boards and all in several counties around this region. I've done from planning work, I will say a lot of your larger communities, from Fairhaven to Carroll Lutheran Village to Lorien facilities. As far as I've testified in front of this board, I didn't list them all, but there's a list of some of them over the years. But it chewed up some more paper.
Mr. Nelson, I'd be happy to revise and say that I'd offer Mr. Hackett as an expert in the area of land use design, given what he's just offered.
Mr. Bell, Chairman Bell, I appreciate the fact that the gentleman has testified before. I appreciate the fact that he's worked hard for his career. But the fact of the matter is, he's not a licensed engineer. He's not a licensed land planner. And I'm going to suspect when he testified before, no one raised those objections.
I've also just clarified that I'm not offering him as an expert in either of those categories, Mr. Chair.
Then could we have a proffer, then a revised proffer of what his testimony is going to be?
Mr. Hackett, I'd be happy to, if Mr. Chair is.
Absolutely, I'm waiting.
Mr. Hackett is going to very briefly testify that he's worked with other clients to develop nursing home uses in the county, that he's aware of what the traditional nursing home model, and that he's been present as part of this hearing and heard all of the characteristics of this use and offer his opinion on whether this is more or less intense than a traditional nursing home model.
More or less what? I'm sorry, I didn't hear that.
Intense,
Intense?
yes.
I'm going to object to that on the basis of lack of expertise.
We've accepted him as an expert, not just this board, but previous boards over the last, Lord only knows how many years, as an expert in planning and site development. So based on that, and based on the projects that are here, I'm looking down over Lorien Healthcare. A lot of projects here. Adams Paradise Assisted Care. There's quite a few projects on here that had to do with care facilities. So we'll accept him as an expert witness in the field of planning and site development.
Thank you, Mr. Chair. Mr. Hackett, you just went through some, but in the history of your career, have you worked with clients to develop traditional nursing homes in the county, in Carroll County?
That's correct.
Can you provide a few examples to us?
Yeah. The Carroll Lutheran Village, I've done a lot of work out there over the years, and Fairhaven. Fairhaven's got a component of that for Alzheimer's, a dementia unit, Copper Ridge, the Lorien facilities.
Are you aware that the term nursing home is a defined term in the county code?
Yes, I am.
Were you present and did you hear all of the testimony offered as part of this hearing so far today?
Yes, I have.
In hearing the characteristics of the use, in your opinion, is there anything about this use that is more intense than a traditional nursing home that you've worked on?
Objection. Same basis.
Nursing homes in general are not very...
Wait a minute. Same basis?
He's offering, yes, sir, I object to this witness offering opinion comparing the relative intensity of the proposed use to a nursing home that was approved in the year 1990, 33 years ago.
I did not
But
ask
the
him.
question was about his experience in projects that he was directly involved with, if my understanding.
That is correct, Mr. Bale. I am not asking Mr. Hackett to state anything about the previous BZA decision, just nursing homes in general and his experience.
Okay. Well, I'll allow him to answer the question.
Thank you.
Nursing homes in general are not super intense uses. They're relatively low for, even though they, some of them are large. When you look at it from a size perspective and traffic perspective. In this situation, and the relatively, what we're talking about, the use exists today for a nursing home, and we're putting the facility that's being proposed is, as we feel, under that realm of nursing home, but has set up to treat differently, if you will. I mean, these people are dropped off, their visitors are not as often, that kind of thing. They have nurses and doctors' visits, and so on, just like a nursing home would, your traditional type. And that's why, we're here today to get obviously the definition confirmed for this use. The use is still in existence today. So we're not here about whether it's a use, but relatively, the traffic on these types of uses are relatively low. And this type would be even less traffic than if it would be a use like your traditional type. They get many more visitors. You don't have to be, it doesn't have to be scheduled and so on. People
Mr. Hackett, when you say that, are you speaking about this use or are you speaking about a nursing home? A traditional
nursing home. When this use, everything's more scheduled as far as drop-offs or any type of visitation.
Those are my only questions, Mr. Hackett.
Mr. Nelson, any further questions?
Yes, sir.
Okay.
Mr. Hackett, in your 35 years as a land planning consultant, have you had occasion in Carroll County to work on cases where your client has applied for a conditional use?
Yes, sir.
So you're generally familiar with the requirements in the Carroll County zoning ordinance for conditional use.
Yes, sir.
And this is not a memory quiz, so if you want to look at the ordinance, feel free. I'm not testing your memory, but I think you'll recognize these words when I read them to you. But section 158.133G is the standard conditional use set of requirements for Carroll County, is it not?
Mr. Nelson, if you'll give me a second,
Yeah,
I'm
take
going to
time.
put it
It's
in
not a
front of
memory
him.
quiz. I think it's 158.133. All right, so in your work as a land planning consultant for these past 3 decades in Carroll County, you've told your clients, if you're going to apply for a conditional use, we need to prove conformance with each of these requirements, haven't you?
Correct.
All right. And you might have used different words, but you probably conveyed the message to your client, look, when we're in front of the BZA, we need to be able to describe this use, what's going to happen on the site, how many workers, how many drivers, what's going to go on there. And you got to talk to, and we need to talk to the board of the BZA about the neighborhood around the proposed use, because those are the central themes of a conditional use inquiry. You've done that, have you not?
Yes, sir, I have.
All right. And then the client says, well, what do we need to prove? You say, well, I'll tell you what you need to prove, because the code tells us in precise terms. Item 1, the number of people residing or working in the immediate area. Tell me, Mr. Hackett, how many people were working in the nursing home in 1990 when it was approved?
Objection.
Have no idea.
I have no idea.
That's right.
All right, and then the client says, all right, what's the next thing I got to think about? You say, it's easy. We go to the code. We got to show that this won't adversely affect the ordinary growth of a community. Code says that, doesn't it?
Yes, sir, it does.
All right. Tell us how this community has changed since the year 1990.
Objection. None of Mr. Hackett's testimony was related to to this section of the code that he's being questioned on, nor did he ever hold himself out as having reviewed this for the initial approval back in 1990.
My point, I'm sorry, I didn't mean to speak windless.
No, go ahead. Your point is what?
My point is, the witness has conveyed the theme based on his 30 years of work as a land planning consultant, that the nursing home, that the proposed use, the drug rehab facility, is no more intense than a nursing home. And the example he gave was traffic, you'll recall. He said, there won't be much traffic. Well, there are 8 criteria in the zoning ordinance for a special conditional use permit, only one of which addresses traffic. There are 7 others. So the comparison of traffic is interesting, but 1/8 of the analysis. And I want to bring out I'm establishing the theme to the board that this witness has no knowledge about the other 7 factors, and therefore his opinion that this proposed drug rehab facility, level 3.5, is no more intense than a nursing home is baseless.
Is what?
Baseless.
Baseless?
But my question is, he's not advocating for the conditional use. That the conditional use is already there. It stays with the property.
Right, but he's saying that this proposed use is the same or no more intense than the original conditional use. And I'm establishing the theme, if it pleases the board, that he has no facts to back that up. He doesn't know how many people were working there, for example, in 1990. How does he compare this use in the year 2000?
But Mr. Nelson, what I'm trying to say is, the conditional use that was granted in 1990 We're not here to discuss that. That was granted in 1990. Mr. Tatura was the chairman of the board. And when that conditional use stays with that. We're not here to get an additional conditional use. We're getting a request for an affirmation that this conditional use is consistent with the conditional use that was granted in 1990.
Well, that's,
And the intensity, we're not looking at the intensity, we're looking at the use, okay? And the conditional use of a nursing facility, it doesn't matter whether it's 3 beds or whether it's 100 beds. And absence of a traffic study that says it would be a detriment to the community, how are you going to define the, how is anybody going to define the intensity difference?
well, of course, the point I made at the outset of this hearing was there should be no live testimony. It was a purely legal argument for precisely the reasons the chair just outlined. That's the point I made to the board, to you, sir. And my adversary said, no, we need testimony. And then my adversary called a series of witnesses. And the theme of the applicant's case is that this proposed use, it should be treated as a nursing home. And one of the reasons it should be treated as a nursing home is that it's no more intense than a nursing home. And my point, sir, is that all conditional use applications are fact-based analyses. You got to look at the use, and you got to look at the neighborhood around it, and the tribunal needs to make a determination, are there any especially adverse effects from this conditional use at this particular location, right? That's the law. We all know it, right? And that was done 33 years ago. So my opening argument is, this is a legal argument, there should be no testimony. I've lost that argument, right? I've made it, I lost it, and now I'm saying, okay, if you're gonna accept this evidence on this proposed use, you can't just look at only the traffic and say this use is no more intense than the nursing home from 33 years ago. You can't just accept platitudes from professional witnesses that this is the same. It's not the same, right? It's a level 3, high intensity level 3.5, and the witnesses don't know how many workers there were 33 years ago when this project was approved. So if you're gonna reject my argument that it's a legal argument only and allow the evidence to come in from the applicant, you gotta allow my clients to present a refutation of what they're saying. This use is more intense. It's a different use.
I don't want to offer testimony. I'll do that in my summations, but there's a certain distortion there that I will address at the end in the end. I don't want to be accused of giving testimony. So, so what was your question again, Mr. Nelson, to Mr. Hackett?
I directed him to the second criteria for the conditional use requirement, which is they have to show there's no adverse effect on the orderly growth of a community. That's what the second requirement for conditional use. And my question was, can he describe for this panel, for this board, the changes in this community since 1990 when this conditional use was first approved?
Mr. Hackett, and I will direct you as I have earlier in the day and earlier in this case. If you do not know the answer to that question, please state that.
Mr. Bale, I'm still processing my thoughts here, but the basis of my objection to that question is not the end portion of the question. It's the comparison of it to presumed facts in case 3441, which we don't have. What Mr. Nelson's pointing out are certain things that perhaps he could have appealed case 3441 when that was decided, but that's not the issue before us. So I did not ask Mr. Hackett to compare the intensity of any of these characteristics to 1990. I asked him to compare them to the other nursing home projects that he has worked on and been familiar with, because all we have before us is that this property was approved for a nursing home. So that's what I've asked him. So that's the basis of my objection. I don't object to him answering the question, but I don't think it's appropriate to tie it to 1990.
Was comparing the previous use at this location to the anticipated use of the property if this is approved.
No, it's Mr. Hackett is offering testimony on his experience
On
of
his- on his
other
I'm
traditional
sorry.
nursing homes compared to what he's heard testified as part of this use.
Okay.
He was not involved in the
I'll absolutely
1990
allow that.
case. Thank you.
Answer.
Yes.
What I can tell you is in 1990, this plan and project was approved by a Board of Zoning Appeals for 68 beds. Those 68 beds operated to approximately about a year ago or whatever. So it's not really 1990, it's up to about a year ago, there was a functioning site. And now we're here to sit there and try to get confirmed that this type of healthcare, or whatever you want to call it, is similar to a nursing home offering it. My testimony that I said about the traffic is real simple. It's most of these people do not drive to the site or off the site as far as the people that are there, the customers or clients. They don't get as many visitors as a traditional nursing home. Therefore, I believe that kind of stuff it's a little less intense use. Inside the building, where he's talking about 3.5 is the level of care, that's what I'm hearing somebody referred to as a higher intensity. Well, I mean, you have other uses of Copper Ridge, dementia, Alzheimer's. Those people, sorry to say, my mom died of that. Sometimes they get angry. Sometimes they wander. They sneak outside. I mean, it's a fact. And that's what we're here today for, is the confirmation. These items, as a conditional use, if I were here trying to get a conditional use approved, which we're not, they're the type. He's spot on. That's what we go by, those items. But that's not what we're here for today. I'll answer any questions.
Okay.
Yeah, all right.
Mr. Nelson.
So I understand you to say, Mr. Hackett, that a conditional use for a nursing home was approved in 1990, and this proposed use for the drug rehab facility, level 3.5, is a nursing home.
That's correct.
And you will agree, will you not, that back in 1990, when this conditional use was approved for the nursing home, the board found that this nursing home would not adversely affect the property values of the houses in the neighborhood?
I'm going to hand Mr. Hackett a copy of Applicant's Exhibit 1, which is the written decision in that case, for his reference in answering that question. Marty, it's just the first page.
I'm sorry?
It's just the first page is that decision.
I don't see any reference to.
All right, but it was a requirement in the ordinance, if they found approval of the conditional use, they would have had to have found conformance with that requirement, would they not have?
Objection. I don't know that that's Mr. Hackett's area to answer that.
If you don't know the answer, Mr. Hackett.
I don't.
Okay.
That's all I have, this witness, thank you.
Ms. Miller, any?
I have no follow-up. Thank you, Mr. Chair.
Okay. Anyone from the audience have any questions of Mr. Hackett's testimony that is not a client of Mr. Nelson's? Board members. Oh, wait a minute. Mr. Bajun, please come to. Yes.
Jeff Bejune, B-E-J-U-N-E, 1306 Buckhorn Road. property manager for the government. I just want to know, are you paid for your testimony?
Absolutely, I hope so.
Okay. All right, thank you. Thank you for.
Any other questions? Mr. Grove, right?
Yeah, Justin Grove, 5272 Frieda Road. Of the projects that you've done in Carroll County, have any of those been for conditional uses in an agriculture area? Like this one is currently approved for?
We've done several type of assisted care, nursing home rehab centers, yes.
But have they been in
In agricultural.
agriculture areas? Okay.
Serve well and septic.
Okay. Last question. Have any of the projects you've done in Carroll County been for a drug addiction facility?
We're currently working on another one.
Okay.
Any other questions? Very good. Board members, questions of Mr. Hackett's testimony?
No questions.
Very good. Thank you, Mr. Hackett.
Thank you.
Thank you, Marty. That concludes the presentation of my testimony, Mr. Chair.
Okay. Mr. Nelson, would you like to call your first witness?
Yeah, I'd like to make a motion to dismiss the application.
On what grounds?
That the application was for a level 3.1 clinically managed low-intensity residential service use, 3.1. That's in the application. And the testimony today was that it's a 3.5. The evidence in the record is in conflict with the application. And we prepared for a level 3.1 case. There was no evidence presented on a level 3.1. The only evidence was on a level 3.5. And for those reasons, we seek a dismissal of the application.
Mr. Chair,
Ms. Miller.
let me gather my papers here real quick. On March 23rd, 2023, I submitted an amended explanation of request that says applicant requests affirmation and potential modification of BZA cases 2782 and 3441 to confirm that a residential addiction service facility is permitted under the aforementioned approvals for a nursing home at the location described in this application and shown on the attached site plan. Additionally, that is how this was publicly advertised, using that language.
I would advise the board that you can't rule on a motion to dismiss. That's a mistake. What this board has to do under the rules and procedures is to listen to all the testimony and evidence and then make a decision. We can't take, you can't take motions to dismiss or, you have to hear all the evidence and then make a decision. So.
Okay. So the request is denied. So, Mr. Nelson, would you like to call your first witness?
Yes, Mr. Chairman. There's a commissioner here who wishes to testify. There were a few of my citizens who wish to testify. I have provided a typed list to counsel for the applicant. I'd like to give a copy of a typed list of my clients to the board. May I do that now, just so that there's a record of who my clients are?
Yes.
Okay, should I make it
Okay,
an
we can-
exhibit?
Yeah, make those an exhibit, Mr. Dixon.
Opposition
We'll share the
exhibit two.
copies.
The purpose of that exhibit, Mr. Chair, is simply to have a formal record of who my clients are in this case. Each of my clients has authorized me to tell the board that they oppose the application. My goal is to call just a few citizens to testify, not each of the 125 citizens. But everybody on that list is my client, and everyone is opposed to this application. But with the chair's permission, I understand that Commissioner Guerin is here and wishes to testify. He's not my client, but as a courtesy to him, I would ask the board to permit him to address the board now.
Mr. Chair, preliminarily, just before testimony, at least one of these people named on here independently cross-examined, so I believe Mr. Nelson had agreed to strike them. I just wanted to, from the list of those he represents, I just wanted to make sure that that made it to your copy.
That's correct. There's one witness that should be stricken from that list who spoke. I need to confirm who that is, but there's somebody, and I can speak with counsel at the next break, but yes, we'll take one name off that list. That was my oversight, for which I apologize.
I believe there were two, but I'm sure we can
We'll
communicate
talk,
about that.
if there are two, there are two.
Okay,
Yeah, we'll work that out.
very good. Commissioner?
Before I speak, may I approach the dais and present some information regarding traffic issues?
Yes. You want to go ahead and hand that to Mr. Dixon, and we'll enter that into evidence.
Thank you. I'll be brief. My name is Michael Guerin, Guerin. I reside at 303 Bridal Wreath Way, Mount Airy, Maryland. I'm here as a citizen, and I'm also here as the District 4 County Commissioner representative of these fine people here. I'm here in opposition of this application because I feel very strongly, having lived in Carroll County since 1984 and knowing that area well, that it is incompatible with that particular neighborhood. And I want to address the issue of traffic. Before you'll see a traffic memorandum back from 2008. There was an issue back in 2008. For those of you who are familiar with Krimgold Park, it's a wonderful park, but we can't use all the fields there because back in 2008, we decided to use the fields. We went to the Mount Airy Maryland Transportation Department, and they did a traffic study and said we couldn't use those fields at Krimgold Park because the area of Route 94 from Krimgold to 26 is too crowded. That was in 2008. I would direct your eyes to number 3 on this particular memorandum where it says, before anything happens at Krimgold to increase usage, and talk about improving site. I need to improve my site. Improve site distance at the intersection of Woodbine Road and Buckhorn Road. So my concern here is a traffic concern. Obviously, I have other concerns as well. You've had people sitting here since 11 o'clock, people that were supposed to be in work probably. I think there were about 70 people here when this meeting started. God bless you all for being here. I appreciate the work the commission does. But I would just ask you to, I know there's some human factors involved in this debate, some serious human factors, and we all have empathy for people, you know, dealing with that particular situation. It's not uncommon in this world today. We're all affected by it in many ways. But I would ask you just to include the feelings and thoughts of these people sitting here as well, because I think they matter as well. So thank you.
Any questions of his testimony, Ms. Miller? Commissioner, you're supposed to stay at the microphone. Is this your first BZA hearing?
I have learned to run from microphones since December.
I just want you to know I go back a long ways with the commissioner. We were on the Planning and Zoning Commission 20-some years ago, I guess.
Yes, we were.
We were both young men then.
Yes, we were.
Ms. Miller, do you have any questions?
Just a few in follow-up to the memorandum, Commissioner Guerin. I'm just curious if you can provide some more context to this in terms of, was this associated with the site plan? Were these mitigation measures implemented? Any additional context you can provide?
Yeah, and my apologies for not having that with me. It's a 110-page document, so I will go ahead and grab that, and I will make sure you get that, ma'am. I would have liked to have brought that with me, but I couldn't quite get my hands on it. But it just was an illustration that there is, in my personal view, a traffic element to this debate.
Board members, any questions of the commissioner?
That was my only question.
Okay, thank you.
Can I sit down now?
Yes,
Thank you.
You can take a seat. Okay, Mr. Nelson.
Mr. Chairman, I'll defer to the board's preference here. I know that different tribunals have different practices with respect to petitions. but I have in my hand a petition that was prepared by some of my clients. It's got names and signatures and addresses of people who are opposed to the application. Sometimes tribunals say our practice is to accept such a petition. Sometimes
We can accept that into evidence. So if you hand that to Mr. Dixon.
And I only have one copy.
And that,
May I see it? And I will object to that exhibit being entered. There are several signatures on there that do not have any addresses or names printed at the back of that petition, so there's no ability to ascertain whether those people are located anywhere near this site or not. I do not object to Mr. Nelson, as we had previously discussed, his list of the clients that he represents and those addresses instead of calling each of those people individually. But that petition does not contain enough identifying information for me to make any statement on whether those people are truly impacted by this type of request or not.
we will go ahead and accept the petition with the noted objections.
Thank you.
Folks, this is our opportunity.
Yeah, go ahead and sit.
This is our opportunity to have a few of you testify. A few told me you wanted to testify. So let's start with you, sir. Give us your name, address, and tell us whether you support or oppose this project and why.
Good afternoon. My name is Ben White. My address is 5175 Stone House Village Court. And no, it does not fit on the street sign. And I am here in opposition of this acceptance of a residential drug treatment facility being classified as a nursing home. I oppose it due to safety reasons. In my own personal experience, I have firsthand knowledge of drug treatment centers, and I know that those residents, and I believe you testified to this, have the ability to leave if they so choose. And unlike nursing homes, the people at drug rehabilitation centers are ambulatory. They can and will leave if they choose to do so. The reason I think it's a safety issue is because on Buckhorn Road and on all the roads connected to Buckhorn, there are no sidewalks, there are no shoulders, there is nothing that protects a pedestrian from being hit by a car. And if these people do not have cars when they enter the facility, and if they choose to leave by walking out a door, which was testified that the doors are open, they have to, egress is imperative, they have to be able to open the doors and leave the building. So people could leave the building at any time. I also wanted to point out that my understanding, according to ASAM, a level 3.5 facility services are designed for people with serious psychological or social issues who need 24-hour oversight and are at risk of imminent harm. That's the definition of a 3.5 facility according to ASAM. So if these people have serious psychological or social issues and are at risk of imminent harm, and they have the ability to leave the facility at their will, then are they not a risk to themselves on a road and in a neighborhood that is not designed at all for pedestrian traffic? So I'm concerned about not only the safety of our neighborhood, but the safety of the people who would be in that facility as well. In a typical nursing home, by a common definition, those people are not typically ambulatory. But in a drug rehab facility, they certainly are. Thank you.
Wait a minute, stay there. Ms. Miller, do you have any questions of Mr. White's testimony?
Mr. White, just one quick question for you. Are you familiar, you said that you had some experience with these types of facilities. Are you familiar with any in Carroll County?
Yes.
Are you familiar with any having safety issues that have arisen in Carroll County?
No.
That's all. Thank you.
Board members, any questions of Mr. White's testimony? Go back to the microphone. You're not dismissed. Board members, any questions?
No questions.
Okay, Mr. White, you
Thank
can
you
take a
very
seat. Mr. Nelson.
Yes, Mr. Lawson?
My name is Michael Lawson. I'm 1545 Buckhorn Road, Sykesville, Maryland. I'm a small business owner. I've prepared remarks. I'm here to discuss why it's inappropriate to define an addiction treatment facility as a nursing home to bypass zoning regulations, especially when it's on agricultural land next to residential areas. Defining an addiction treatment facility as a nursing home is like changing the label on a product. Just as relabeling a landfill as a park or a brothel as a health clinic to bypass zoning regulations would be misleading and potentially dangerous, defining an addiction treatment facility as a nursing home to bypass zoning regulations is misleading and potentially harmful to the community. Addiction treatment facilities and nursing homes are fundamentally different in their purpose and function. While nursing homes specialize medical care and support the elderly individuals who need constant attention, addiction treatment facilities offer specialized care to individuals suffering with substance abuse disorder. Therefore, it's inaccurate and misleading to classify an addiction treatment facility as a nursing home. Allowing an addiction treatment facility to operate on agricultural land next to residential areas could undermine the integrity of zoning regulations, lead to a loss in confidence in the zoning process. It could also open the door to other commercial activities that may not be suitable for the area, leading to a decline in the quality of life of residents. Furthermore, calling an addiction treatment facility a nursing home to bypass the zoning regulations would be similar to calling a nightclub a restaurant or, again, a brothel a health clinic. It's misleading and potentially harmful to the community, and the purpose of these functions or these businesses are fundamentally different. And I think we're all, on some level, completely aware of that. The gentleman that was up here that broke his leg would not have gone to a drug rehab facility to help his leg, because that's not what nursing homes do. When each of you retire and are old and may need to go to a nursing home, you're not going to go to a drug rehab. They are fundamentally different things. And I've made a slight list here. Landfill as a park, a casino as a community center, a factory as a residential building, a nightclub as a restaurant, a car dealership as a parking garage, and you can go on and on. If you're just trying to classify something to sort of scoot in, you could come up with all kinds of definitions. If I bought the theater on Main Street in Westminster and wanted to put a strip club in it, is it no less entertaining than it is right now? It's not the same thing. They're fundamentally different on their face, and that's all I have.
Ms. Miller, do you have any questions of Mr. Lawson's testimony?
I do not. Thank you, Mr. Chair.
Board members? Thank you.
Thank you.
We call Patrick Denetta now, and could he come to the bench, because I'm going to show him some exhibits.
Okay.
Mr. Dixon, could I have a copy of the, I think it's the photograph of the house. This is marked page 2 of 6. I marked a separate, I tore up page 2.
Oh, you want yours?
Yes.
Okay, I'm sorry.
Dennett, tell the board your name and address, please.
Hello, my name is Patrick Denena. My address is 1443 Buckhorn Road, Sykesville, Maryland, 21784.
Now,
And can you spell for the record your last name?
Dinenna.
Thank you.
Mr. Dennett, how far is your residence from the existing nursing home, the structure, and the proposed drug rehab facility?
142 feet.
Now, the applicant introduced into evidence Exhibit 2, a packet of 6 photographs, which the board has in front of it now. And I asked the applicant to look at page 2 of that exhibit, page 2 of 6. And I asked him whether there was a structure in that photograph, and he was unclear what I meant by the word structure. So I said, is there a building there? He said, yes, I see the building. And then I circled the building in blue ink. And I asked him, is that building part of the existing nursing home? And he said, yes. What is that building that's circled, that's within my circle that I drew there?
That, sir, is my home.
Now, then I'm going to show you a copy of an aerial photograph. I have multiple copies for the board, Mr. Dixon. Now, help me identify that photograph, sir. What is that aerial photograph of?
Well, I see two call-outs. I see subject property outlined in red and Crim Gold Park outlined in green.
Do you recognize that part of the county?
Absolutely.
Mr. Dixon, what number is this, sir?
Opposition Exhibit 5.
I have this marked as Opposition Exhibit 5 for identification. Is this a reasonably accurate aerial depiction of the subject property and surrounding land, including the park and your property?
Yes, sir, it is.
I'd like to move into evidence Exhibit 5, please.
And we'll accept that into evidence?
Mark, this next exhibit for identification is exhibit, Testance Exhibit, Opposition Exhibit 6. Will you describe that, identify that document, please, just generally, in layman's terms?
Well, layman's terms, it looks like the various plots or properties in our neighborhood.
All right, so you can see the subject property there, and you can see where your property is, for example.
Yes, sir.
All right. At this time, I'd like to move into evidence Opposition Exhibit 6.
And we'll accept that into evidence.
Mr. Dennett, this is your opportunity to share with the board whether you support or oppose the subject application, and if so, why?
Oh, my goodness, I absolutely oppose it. And that's an interesting question, why? I hadn't thought about that, but let me just say on the record, I have a sympathy for people suffering from medical conditions and drug addictions. And to me, this is not what this issue is about. To me, it's words have meaning. And the conditional use of this property across the street from me was a nursing home. And, you know, look, I was an officer in the Maryland Army National Guard. I was vice president and then president of the Winfield Recreation Council. We oversaw Crimgold Park. And I just tell you that because I'm a big believer in following the rules. And, you know, to me, if they were the same thing, they'd be called the same thing, but we're using two different names. They're different. Did I answer your question?
All right, well, tell us, can you give us a sense for the proximity of the very nearby properties to the rehab facility?
Thank you, yes.
You mentioned your house is
So
140.
if I'm staring out my front window, like I'm looking at Mr. Bale, that's where the nursing home is. And immediately to the left is another residence. I want to say it's 1502 Buckhorn Road. And that property, that residential property, is 71 feet from the structure of the nursing home. As I already, and it's my understanding, I follow the rules, minimum distance for the nursing home should be 200. I'm directly across the street from the nursing home on 3+ acres, and my interpretation, understanding of the law is minimum distance of 300 feet, and as I already mentioned, I'm 142 feet. And then as I look at this map, to the right is another dwelling, and it's also on 3+ acres, and its distance is 173 feet from the nursing home. And then I would like to just mention to the immediate left, the property, the 1502 Buckhorn, they can't be here. They traveled to out of state for a funeral, but they have 3 young children. I have 5 children, and then to the right of the nursing home is a property with 4 children.
Is there anything else you want to tell the board as to why you oppose this?
Since Mr. Nelson asked, it's a safety concern. I've heard testimony where, frankly, people can voluntarily leave the proposed facility. I'm right there. I've been there for 30 years, and I've spent when I moved in, my property was the worst property on the road, and I've been working over 30 years to improve it. And why am I telling you that? I guess for safety reasons, I'm concerned. Why did I tell you that? But for my family and the neighbors.
Thank you, Mr. Dennis.
Ms. Miller, do you have any questions?
Just a few. Good afternoon, Mr. Denena. I am looking at what was marked as your Exhibit 6. I believe you still have a copy of that in front of you.
Yes, ma'am.
Can you is there any reason that some properties are blue on there? Like, are they being called out for a specific reason, or was that?
I don't know.
Okay, I'm just curious.
I can tell you off the record, if you want, I could say it on the record if you want me to, but my office did that. But
Okay. I was just curious if that was any part of what was being shown on here, those being of special importance or something.
no, that's where some of our clients
Live. Okay. Mr. Denena, you just spoke to some of what you believe the required setbacks for the county are for
Yes, ma'am.
uses. Are you citing to something specific, the code or a specific reference that you found?
I want to say, again, I don't know the official language, but 158.040 talks about distances.
Okay, okay.
And to me, it makes sense that you wouldn't want a rifle range right next to a school. You'd want X amount of distance. So those things are important. That's why I brought it up.
Are you aware of whether a nursing home is a use that's subject to 158.040?
I am. My understanding of that is it is. So depending on the use, you guys know this, I'm sure, that depending on what conditional use is in effect, the distances go up. I used the shortest distances because I didn't want to misinterpret the regulation.
I understand where you're coming from, Mr. Denena. I'll address it in my closing, but I think I think maybe you're just misreading that section of the code, but that's fine. You're not holding yourself out as a zoning expert, so I'm not going to hold it against you by any standards.
Well, if I may, thank you. I have conservation, and I have a conditional use. We run a kennel on that property, and I remember I had to maintain X amount of distance from my neighbors, so that's why.
Yes, you probably were subject to distance requirements as part of that, but I appreciate that clarification. Thank you. I have no further questions of Mr. Denena.
Any questions from the board on his testimony?
No questions.
Very good, thank you.
Just 1 second now. I'd embarrass you if I fell asleep. Mr. Ader here? Yeah, you're next. You can testify from the microphone. Give us your name, address, and this is your opportunity to tell the board whether you support or oppose this application.
And spell for the record your last name, sir.
My last name is Ader, A-D-E-R, David. I live at 5241 Stonebridge Way, and I am retired. My whole issue is I'm opposed. My whole issue is the use, and for me, it's apples and oranges. We're not talking.
Can you step a little bit closer to the microphone?
We're not talking about somebody who is getting out of the hospital and convalescing. We're not talking about somebody with a broken leg. We're not talking about somebody who's got dementia and they're in a nursing home. We're talking about a drug rehab center servicing people with addictions, and in this case, some pretty severe addictions. So for me, the issue is use. And we've talked about, is it court-ordered or is it voluntary admissions? And the gentleman says it's voluntary admissions too, and people, we can't, in his own words, it's not a prison. We can't keep people there. If somebody wants to leave, they can leave at any time. Whether they choose to go through their checkout process or not, they're free to leave. Now, my history, and it's a lifetime ago, I'll tell you that, is I'm a former policeman in Howard County. I can't tell you how many times that I was called to find people who walked away from Taylor Manor Hospital, people who had psychological issues, people who had addictions. How many times I've had to find people from Springfield Hospital that walked away. These were closed facilities, controlled facilities. And they walked away at all hours of the day. I will tell you this about people with severe addictions, and this isn't news for anybody. People who are unemployed or who are underemployed, who have severe addictions, severe drug addictions, need to be able to feed their addictions somehow. And if they can walk away, they're going to walk away a lot of times. I had to chase them down. Okay? Those people have to find a way to get money to feed their addictions. And how do they do that? I'll tell you, because I was also a detective in Howard County. And I investigated literally hundreds and hundreds and hundreds of breaking and enterings. At all hours of the day, a lot of times during the middle of the day. Most of the time during the middle of the day when both parents, both property owners, the owners of the property, they needed two incomes to be able to pay their mortgage. And a lot of times there was nobody left in the community. Nobody left on the cul-de-sac. And it was easy pickings. And so people who had these addictions would walk away from facilities or would come into the neighborhoods and they would break into the houses. and they would steal the property of other people. And they would take that property and they would go to a local fence and basically sell that property and get money to buy their drugs. My concern is the use of this property. It is a drug rehab center for level 3 chronic severe addictions, where they can walk away at any time. I'm concerned about that. That's my concern. That's why I'm opposed to it. It's not for somebody getting out of the hospital. It's not for dementia. It's somebody with an addiction. That's what we're concerned about here. That's what this neighborhood's concerned about. That's where I am with this.
Ms. Miller, any questions?
I just have one question of Mr. Ader. Mr. Ader, do you have any familiarity with facilities that are owned or operated by Mr. Stempler?
I have no knowledge of any Mr. Stifler's facilities.
Okay, board members, any questions of Mr. Ader's testimony? Thank you.
Sir.
Mr. Nelson.
One moment. Any other citizens who wish to testify, understand that I've told the board, I've introduced into the record the names and addresses of all my clients. The board understands that each of you is opposed to this application, but if there's anyone who wants to speak, in addition to that, this is your opportunity. There's one gentleman in the back.
Am I able to
What-
ask
what-
a question?
No. This is an opportunity for your own testimony.
Okay, that's fine. That's fine. I think we can be
Wait,
honest.
whoa.
Jeff June, B-E-J-U-N, I thought you'd get to know me already.
No.
B-E-J-U-N-E, 1306 Buckhorn Road, a property manager for the federal government. So I think we all got to be honest with ourselves and know 30 years ago, if they came before the board and said, hey, we wanted to open a drug rehabilitation center where we'd have addicts addicted to substances like fentanyl, meth, right? We know what the answer would be. We have to ask ourselves that. And then 2, what they're making their case on, and I've been here before. I've been a chairman of a planning commission, and I've seen them trying to make a square peg fit in a round hole by making that definition fit. So what the neighborhood's attorney said was, well, aged. Well, then the other attorney said, well, it's the convalescence. Well, the definition of that is recovery or health and strength after the disease. And that's by the Webster definition. I believe she was citing Webster. Or between the substance of a disease, that's after the disease, and the complete restoration of health. So this is after. Convalescence is after they've been treated. They're going there to get treatment. So make no mistake, it doesn't fit. You can't make that definition work. And then as a planning commissioner, in the back of my head at all times, you have to be aware what you do, your decisions will could possibly hand-tie the town and future planning commissions. So it sets precedents. So if you say, well, a drug rehabilitation program fits under the definition of a nursing home, you just said, well, any nursing home here, a lot of nursing homes are for profit. If it's more profitable to run a drug rehabilitation center than a nursing center, what are you going to see more of? And you can't stand on it anymore, right? You set precedent. You set the rule for years to come that will hand-tie the planning commission and the town. So I'd like you to think about that before you make your decision. There's severe consequences. Thank you for your time.
Ms. Miller, wait a minute. That's your third time to the microphone and you forgot the rules. Okay, Ms. Miller, do you have any questions?
Just one brief. Mr. Bajun, you just talked to the board about the legal precedent set by their cases. Do you have any legal basis for telling them that their decision set a legal precedent?
Yeah, well, my experience as a planning commissioner, and we always had legal counsel, so we were always made aware our decisions had lasting impacts and
Okay.
could be brought up in litigations in the future.
And you recognize that Planning Commission is different than the Board of Zoning Appeals, correct?
Either way, it can be brought up in litigation. I do recognize the difference.
Okay.
But it can and will be held against you if need be. We're all on record, and that decision will last forever, that you possibly that you determine that a drug rehabilitation center fits within the nursing home definition. So that could be used. I mean, you wouldn't have a leg to stand on after that. So
I
understand the severity of this decision.
I appreciate your opinion on that. I would legally disagree with you, but that's okay. I appreciate your opinion on that. Thank you.
Okay, board members, any questions?
None.
Okay, now you can go.
All right, I won't be back.
Don't make that promise.
Hi, I'm Dory Walden, 1302 Buckhorn Road.
Spell for the record your last name.
Walden, W-A-L-D-E-N.
Okay, go ahead.
I am obviously opposing this. I am 6 house fronts away from this facility. Through the Woods is a direct link, to my house. I have 4 kids. I have one that gets off the bus by himself. It's kind of a latchkey situation, but why we're getting home and going to work between me and my husband and my older child. And I don't want to have to start worrying that someone decided to walk out of the drug facility and needs to break into somewhere close, because I am close. I have a direct link to this addiction. My brother was addicted for years and has been sober 12 years. He got the help he needed. Amazing. He's, I know that it can be done, but I also know that every single person in the facility with him when he got sober is dead. He is the only one out of his whole group that lived. He is very involved in AA and NA, and I know the statistics of these facilities that it's sad. The majority don't come out sober. The majority come out, they might walk out of the door sober, but they go right back to it. And that's just the sad facts. And I believe that we need many more of these facilities, but they don't need to be in a residential neighborhood. They need to be in a commercial environment, a hospital environment. There are so many retail spaces available in Carroll County that sit empty. All of us drive by them all the time. There are so many places that this could go. It doesn't need to go on our little sleepy street that could very well turn everything around for us.
Just wait. Don't abandon
I'm
me.
not leaving. Okay.
Ms. Miller, any questions?
I do not have any follow-up. Thank you.
Board members? Okay, thank you.
Anybody else?
Okay, anyone that's not represented by Mr. Nelson, do you want to make any comments? Wow, good. Okay. Presentation of testimony and evidence is
Mr.
now
Vail,
closed.
I'm sorry, I have to interject because I have the opportunity to offer
Yes.
rebuttal.
Yes, go ahead. I didn't see you get my attention, so.
That's okay.
No, go ahead. Better-
Okay, we'll go ahead. After her rebuttal, we're going to take about a 5-minute break.
Would you prefer to, I'm fine if the board would
No,
prefer
go
to take
ahead,
one.
go ahead and do the rebuttal.
Okay, okay.
It's not going to be an hour, is it?
I hope not.
Okay.
I'm going to call Robbie back to testify. Robbie, can you please introduce yourself and state your name and address again for this board?
Robbie Stempler, STEMPLER, 400 Redland Court, Owings Mills, Maryland, 21117.
Mr. Stempler, you heard a lot of testimony just now, but we're going to go through it a little bit. From Mr. White, you heard some testimony about the doors being open and the potential safety risk thereof. why does the front door need to remain open?
Yeah, I heard that.
Why do you have to keep it open?
Because this isn't a jail, and I mean, open, it's not open, it has to be unlocked.
Right, I'm sorry, I should have said unlocked.
Because this is imprisonment. These are people that want help and are willing to get help.
Would it pose a fire safety risk if that were locked?
Yes.
You also heard Mr. White speak about the risk of imminent harm. I think he was mentioning the 3.5 service characteristics when he talked about that. Is that risk of imminent harm of self or of others?
No, it was a complete mischaracterization. What he was describing would have, been someone that would need to be, in a high intensity psych ward against their own, admitted against their own willingness.
You heard some testimony from Mr. David Adder, who I believe said he was a Howard County, former Howard County police, and his experience in being called for people who walk away from certain types of facilities. Is that a situation that you've ever had to deal with at any of your facilities?
I mean, first, thank you, Mr. Adder. I think you said you were a policeman in Howard County. And I think this is kind of the bigger issue that we deal with right now. Definitely in Maryland, being like the fourth most overdoses in the country, but more so in the country, that, what was described was how it was 30 plus years ago, where these addicts were, criminals, and we're going to rob and we're going to steal. What we're dealing with today is the opioid epidemic. We're dealing with a mental health crisis. There's no discrimination. Everyone has a one-to-one connection somehow with someone that's affected by this disease. And this whole idea that addicts are these criminals that are going to break into your home and rob you and do whatever is in my humble opinion, the problem with what we're dealing with right now to try to solve this epidemic. I mean, this is an epidemic. I went off a little bit on a tangent,
that's
but
okay.
I hope that answered your question.
It did, and my next question was, you've spoken to your experience in operating these types of facilities, but can you again confirm for the board whether you've had any safety concerns in community settings at these types of facilities?
I have not in any of my facilities, no.
Those are my only rebuttal questions.
Mr. Nelson, any cross-examine?
I have nothing.
Okay. We're going to take about a 5-minute break, and at that point, we'll come back for summation. I'm going to leave testimony open in case there's anything else, and then we'll go right to summations, okay?
Thank you.
Ran away.
I'm gonna get her client. Okay, one last chance, both councils. No more witnesses?
None.
None.
Okay. Presentation of testimony and evidence is now closed and summations are in order. Ms. Miller, you get to go first.
Thank you, Mr. Chair. Let me just, with this board's indulgence, I'll take 1 second to get my papers.
Mr. Nelson, then to let you know the procedure, you'll go after her and then she'll have the opportunity to rebut.
Thank you.
Okay?
I'll adjust.
This board has heard a plethora of evidence today, all of which I think is relevant and all of which I'm glad has been presented to you. As I said during my opening statement, I believe that it's important for this board to look at the characteristics of this use to determine whether this use meets the definition of nursing home in the county code. But the ultimate decision here today is, does this use or does it not fall under the definition of nursing home in our county code? We've heard a lot of evidence and testimony about comparing hypothetical, a brothel to a healthcare facility, for example. If those are defined terms in the code, then we also have to work within those definitions. Our code provides for a general retail definition. And then general retail is anything that meets the definition of general retail. Our code does not specifically say a Walmart is allowed in this district, a Target is allowed in this district. It says general retail, and then that user has to come forward and make the case that those characteristics meet that definition. The case before you today is very similar to that. Right now, we are looking at a defined term in the county code, a nursing home. The previous BZA decision is relevant, case 3441, because it approved the conditional use of a nursing home. So it did not, it's relevant for the purpose of now this board is looking at what is a nursing home and what does a nursing home include and what's allowed under that approval. The definition of a nursing home, as you all have in front of you, is a residential health care facility which provides institutional lodging, nursing care, personal care, and supervision to aged, chronically ill, physically infirm, or convalescent patients who are not related to the owner or administrator of the facility. You have heard testimony, uncontroverted testimony, that this is a healthcare facility where patients reside and have institutional lodging, if you will, that there is nursing care provided there, that there's personal care, and that there's supervision. You've then heard testimony about the definition of chronically ill, and specifically chronically ill and convalescent patients. Those dictionary definitions, because our code does not define those terms. We can't turn to our code and say, oh, here's a definition of chronically ill within our code. So as Mr. Nelson stated, what we then do is we look to the plain meaning of those words. And the plain meaning of those words is found no better than in just a regular dictionary, not a legal dictionary, not anything like that, just a regular dictionary. That's why those 3 exhibits were presented to you, showing the Merriam-Webster definitions of chronic and convalesce. And if you look at, the different forms of those words, it covers chronically and convalescent if you flip through the pages of that definition. But a chronic is a continuing or occurring again and again for a long time. That is exactly what you heard testimony from Mr. Stempler as speaks to these addictions, that they are recognized in the industry as a chronic condition. You also saw the definition of addiction, which contains the term chronic in there as well. The term convalesce is defined as to recover health and strength gradually after sickness or weakness. There is not a magic period of you have to be cured and then you go through a rehab facility. You have to look to the plain definition of convalescent, or convalesce in this case in the dictionary. And this is, all of the testimony has been geared at, that's exactly what these facilities serve to do. They serve to help someone recover the health and strength. The characteristics that you heard testified to from Mr. Stempler are important to note, because I'm not asserting that they're the same as what was testified to in 1990, because I wasn't part of that case, and we don't have the decision in that case does not go through all of the specific characteristics that were presented as part of that case. All we have before us in that decision that this board is looking at is a nursing home for 68 beds was approved. But in terms of the testimony that was presented in comparing the characteristics of this use to a traditional nursing home style business, they're very similar. And the reason that I presented testimony on the sections of the code that guide the licensing requirements for these establishments is because the state recognizes them as both healthcare type facilities and regulates them accordingly. I think that's important to note. There's a lot of stigma, as Mr. Stempler kind of just said in a nicer way, perhaps, about drug addiction. And that's what we've heard a lot of testimony on today. That's not relevant to your consideration of this case. I don't dispute people testifying and sharing their experiences or anything of that nature, but that's not the question before you. The question before you is, based on these characteristics of the testimony that you've been presented, does this use meet the code definition of nursing home? I think it's important to note that this property is agriculturally zoned. It's in an area with conservation zoning and some residential zoning. A nursing home in our code is allowed by conditional use in all of those zoning districts. So this shouldn't be looked at differently because this is in the ag district. This is something that could have been applied for in any of those districts. I will note that the one property that wraps to the right, if you're looking at the front of the building, to the right and wraps around the rear of that, came through a conditional use process before this board for a landscaping company, I'm going to say, a few years back. That property directly borders this, and to the entire side of it and to the rear, and we've not heard opposition from the owner of that company there. A chronic condition would be before you if this was a diabetes clinic, okay? The definition of chronic is important here. That's why you see these definitions submitted from the Merriam-Webster dictionary. I think Mr. Donena, I'll say, he said it best. He said words have meaning. Words do have meaning. When a property owner buys a property, if they're doing their due diligence, they look at the zoning and they look at what is allowed in those districts. And what they look at is, if they look in our use chart and they see nursing home, they turn to the definition section of our use chart and they go, what is a nursing home? And that is what they are allowed to do on that property. Some uses are not specifically defined. For example, a restaurant is not specifically defined in our code. So if we were before you with that request, we'd be saying why we are a restaurant, and you'd have to make that decision. But right now, we're here before you with a very specific definition. So it gives you, this board, a lot of guidance in what they should look at in terms of determining something is or is not a nursing home. I believe Mr. Nelson made the point in his opening statement, and I just want to briefly touch on it, that drug rehab clinics are disallowed in the industrial park section. That, unfortunately, or fortunately, depending on how you look at it, the industrial park section of the county code contains uses that are not listed in the use chart. So it doesn't mean that they're not allowed in other districts. It's just an anomaly that perhaps one day will get cleaned up and the use chart will match those prohibited uses in the industrial park. But that's what you're seeing there. And the testimony that you heard from Mr. Voigt is that, for example, a methadone clinic exists in the county and has been interpreted as a doctor's office because it meets those use characteristics. So that's a similar situation where you have this industrial park language that's just kind of a red herring here and not relevant to to your analysis, it does not mean that a residential treatment facility is not allowed anywhere in our zoning district. That's not how that should be interpreted. This is not a mechanism to substitute one use for another use. This is an analysis of this board. That's one of the statements that Mr. Nelson made in his opening statement. This is a request of this board to analyze the language and the code definition of nursing home. A substitution of use, some codes allow for it, some don't, ours do not. That's not any part of the request that's before you today. That's kind of what some people call a use variance, which is not what we're here for today. The purpose of the agricultural district, which was also cited by Mr. Nelson in his opening, is not a binding part of the code. It guides the code and it guides planning principles for what occurs in the agricultural district, but what controls here is the use chart contained in the code. And the use chart very clearly, as the former BZA decision states, a nursing home is a conditional use in the agricultural district, and so now we're left with looking at the definition of a nursing home. These decisions by this board, contrary to some of the citizen testimony that you heard, are not legal precedent. They might be used to show similarities to other cases, or my property is similar to this property and it had a similar request, but they are not legally binding precedent on this body. So I just wanted to clarify that as well. I would request that this board approve or affirm, if you will, that this use falls within the definition of a nursing home. I think you heard uncontroverted testimony from my client and from Mr. Voigt that all of the characteristics of the use go towards meeting that definition. So with that, I would cede to Mr. Nelson.
Mr. Nelson.
Thank you. Thank you to the board. It's been a long day for each of you, I know, but we're near the end of it. You have in your record the list of my clients, and I really lobbied them aggressively not to consume a lot of time with their testimony, because I think this case is a legal question, and I was trying to be respectful of everybody's time. But each of those people who are on that list, save the one or two people that we're going to correct when I speak to the council privately after the hearing, is one of my clients, all of whom are opposed to this application. Let me just start with two legal premises. The first is, there's no mechanism in your ordinance authorizing the board to grant the relief requested by the applicant. My adversary has argued to the board, there are lots of instances where you go to a use table and they don't have a use on the use table that precisely uses the letters to describe your use, the word. So you have to come in and apply for a conditional use, say, and say, we are essentially the same as the use that's on the use table, either by right or by conditional use. And so I envision that, like if they'd applied for a conditional use here, or if they formally applied for conditional use, there would have been, the threshold question is, are they a nursing home? We would have litigated that question. And then if the question was yes, can they satisfy the requirements in the Carroll County zoning ordinance? That's the authority the zoning ordinance grants to you. The ordinance doesn't grant you the authority to after the fact, 33 years after the decision was made, to say this proposed use is what was approved back then. So as a threshold matter, I assert the code doesn't grant you the authority to grant the relief requested. That's the first legal premise. But if you're going to get into the case, the second legal premise is, who has the burden of proof? The applicant has the burden of proof. So we all know what the burden of proof is, that if your minds are in equipoise, they lose. If the evidence is balanced, they lose. They have to prove their case. We assert legally and factually they didn't. But let's just talk about the burden of proof. The witness, the applicant, looked at page 2 of his Exhibit 2, pointed to a house owned by my client, and said, that's part of my facility. This witness said, that house owned by my client, which my client has restored over the past 30 years, he said, he has so little understanding of this site that he didn't even know that wasn't part of his facility. I think that's relevant to the burden of proof. It's certainly relevant to how my clients view the applicant's understanding of their community if they point to a nearby house and say that's the drug rehab center. Let's talk about the legal question. Is a drug rehab facility a nursing home? We say no. Here's why. We've talked about the definition of nursing home. We could probably all recite it from memory now, can't we? I won't do that again, but we have that in the ordinance. We've talked about the fact that there's no definition in the zoning ordinance for a residential addictions center. I pointed out to you in my opening remarks that the zoning ordinance does use in the same section the phrase nursing home and drug rehab facility, and says neither is allowed in industrial park. My point is that's an example of how the county commissioners, the legislators who enacted this ordinance, they recognized that these were two uses. They described them separately in the industrial park section, said that each is prohibited. Council says, oh, it's a red herring, it's an oversight, we'll clean that up, don't worry about it. I say as an advocate of my clients, that's evidence that the commissioners in their minds saw these as separate uses. That fact is compounded by the fact that the state regulatory bodies there's a separate regulatory regime for nursing homes in the state system and a separate regulatory regime for a drug treatment center in the state regulatory regime. So to me, that's further evidence that these are two separate uses. And then you might ask, well, okay, Nelson, if we can't have a drug rehab as part of a nursing home in the ag district, where can we have it under the ordinance? If you're so smart, you might ask me. Here's my answer. We look at the definition of a hospital. Hospital includes any health-related facilities that includes a rehab center. So I believe, as an advocate for my clients, that no zoning ordinance is perfect. We could spend the next 6 months redoing this ordinance. But I believe a fair reading of your ordinance is that a drug rehab facility is a rehab center that can be associated with a hospital. That's what I believe. And then we can go to the land use table and see where are hospitals permitted. And that's where you can have a rehab facility associated with a hospital permitted in those zones. Let me talk about I'm sorry.
I'm sorry, I didn't mean to interrupt. I was processing what that answer is, what zone hospitals were allowed in.
I'll have it here, right here. It's hospitals are permitted as a conditional use in the R20,000 zone. Medical centers are permitted in the commercial and employment zones. But is the answer.
Thank you.
But let me fall back and touch on the purpose because of the zone, because this really informs, I think, the question of whether a drug rehab center is a nursing home. So we lobby on a lot of zoning ordinances, and we lobby and we advocate for text amendments that tighten up zoning ordinances and we try to express opinions as to what uses should be permitted in what zones, and we try to provide a logical, land-based argument in support of that position. So, to me, if you're asking the question, we know that a nursing home is permitted by conditional use in the ag district. And we have this legal debate, well, is a drug rehab facility a nursing home? I think we're obligated to look at the purposes of the ag zone to help inform our analysis as to whether a nursing home is permitted, whether a drug facility, rehab facility is really a nursing home. And my adversary says, oh, she waves her hands at the they don't mean ag. Well, in my world, they mean an awful lot, because they inform our analysis as to what uses are permitted in the zone. All right, so we know from the purposes, the ag district is to promote agriculture. That's the fundamental core principle. And then they say that commercial and industrial uses are limited to those uses intended to serve the agricultural industry and residents of the area while maintaining the character of the surrounding countryside. That's section 158.070A. Everyone in this room knows that there's a addiction crisis in this country. Everybody knows that. But the purpose of the ag district is to have non-agricultural uses that serve the local agricultural community. And we assert that a nursing home does that. Even farmers get old. But a drug rehab facility, level 3.5, is not a locally based facility. So for all those reasons, on behalf of my clients, we respectfully urge the board to deny the application. Thank you.
Ms. Miller, do you have any
I do. Thank you, Mr. Chair.
rebuttal?
Mr. Nelson just spoke about the board's authority to grant this remedy that's been requested, and he cites back to the 1990 BZA decision. Just because it's from 1990, it does not expire. You heard Mr. Voigt's testimony that if I am exploring the use for a property and I come into the zoning office, whether it's being actively used for that or not, we're not talking about a non-conforming use here, okay? We're talking about a conditional use. If I come into the zoning office and that property has an approval for a conditional use and I meet that decision, then it's the interpretation that I can continue that use, do my use under that existing approval. Really what we're looking at is the definition of nursing home here. I don't think anyone's questioning the 1990 validity of that BZA approval that granted the conditional use for the nursing home, because if they were, that appeal period has obviously expired. What we're talking about is the nursing home definition. Mr. Nelson spoke to the burden of proof that I have, and his one thing that he points out as to why I did not factually prove my case is because my client misidentified a structure in a photo. A structure that, if you refer back to the photo, is partially obscured by trees also. Certainly not the most clear photo to begin with. I think that's a pretty weak basis to say that I did not factually prove my case, if that's the one instance that we can cite to, when you've heard a lot of testimony from 3 witnesses of mine today that show that this meets the definition of a nursing home. The site to the industrial park says drug rehabilitation clinic. It's not even the same type of use that you've heard testified to here today. So to say that because it's listed as a prohibited use in an industrial park, so it shouldn't be allowed to be argued as a use that's allowed as a nursing home, just doesn't hold up. We are not a clinic. A clinic is more of a doctor's office type use. You heard Mr. Voigt testify again to the methadone clinics. That's the type of use that's prohibited in the industrial park. The industrial park is a blend of our industrial and commercial zoning district that allows for a mixed use development. It's inapplicable to this case here today. the hospital definition was, I would assert to you, slightly mischaracterized. A hospital is a defined term in our code. And after the definition of a hospital, it says such health-related facilities shall include but not be limited to ... And that's where you see the rehabilitation clinic, which Mr. Nelson is citing for the reason that you then couldn't find that our use meets the definition of a nursing home. A hospital, in any zoning district in our county, I could argue to you that some use is an accessory use because it meets the definition of accessory. It's similar here. It's accessory to the hospital. That's why it's included in that definition. It's not a separate use that's being called out, because if it were, you'd find it in our use chart as a separate use that's allowed in the same districts where a hospital's allowed. But that's not what you see. Mr. Stempler's testimony about the levels of service that these facilities operate under, he spoke to the ASM levels 3.7 and 4.0. His testimony was that those are the levels of service that rise to the hospital characteristics of use, if you will, and that's how it's been interpreted in surrounding jurisdictions. That's not what he's requesting on this property. All of his testimony has been about a 3.5 level facility. That goes to my next point, which is that this is not just any drug rehab, as Mr. Nelson is kind of asserting in all of his statements. This is a very specific, characterized facility defined by the state and regulated by the state. So it's important for you to take that into consideration, just as it would be equally important if our testimony was that nobody is staying there and this is an institutional lodging, because then arguably we don't meet the definition. So I think you need to keep that in mind. Approximately 80% of Carroll County is ag, okay, is agriculturally zoned property. So to say that, first of all, I don't think that the purpose section of the ag district governs any of your decisions. I think it's guidance. That aside, to say that 80% of our community couldn't benefit from some kind of facility like this, I don't know where we're coming up with that sort of data, but I'd be willing to bet that we have a large portion of our community that could benefit from a facility like this. So I don't think that we should pay too much credence to the purpose section of the ag district. If a nursing home weren't a conditional use, that would be relevant. But a nursing home is in our code as a conditional use allowed in the ag district. You then do not need to refer back to the ag purpose section to see that. The legislative intent was in drafting the language for the nursing home definition and then including a nursing home as a conditional use in the agricultural district. That's what this board needs to look at, and then look at the words in that definition. And I think all of the testimony that we've presented has clearly shown that we meet that definition. So again, with that, I would ask that this board approve the request before you.
Okay, the hearing and record of this case is now closed, and in accordance with the Open Meetings Act of Maryland, the board will now consider the case. Board members.
Who wants to go first?
Who wants to start?
I'll start.
Did you volunteer?
I volunteered.
Okay.
Okay, I don't like this at all. I heard a lot of testimony from the residents, concern about safety, but I didn't hear anybody complain about the fact that the nursing home was there for 32 years or thereabouts, or any complaints about people wandering around or whatever. So nobody mentioned that. They talked about property values, but property values have certainly increased over the last 30 years, quite steadily, apart from 2007 and 8 when we had a housing meltdown, quickly recovered and came back up again. About the zoning code, there is no separate definition for a drug-related facility. And the code is not perfect by any means. It's a catch-all. As being presented here, you can't define every possibility out there. So, according to the zoning administrator, he thought the nursing home was the best fit, and I see that as being true. Then you get down to the facts about, really it's all about not in my backyard. Then where would you put it? And I think under Pritz versus Schultz ruling, it can go in any other location, it can go here as anywhere else. I don't think that allows you to sort of throw that out. The other issues that have been addressed, that Mr. Nelson's comments were addressed by Ms. Miller. I'm not going to go into that, but these are the key things that I'm seeing right now. I can understand and sympathize with the residents, but, we're here to, deal with the code as it's written right now. It's not perfect by any means. It's constantly being changed. It's not always changed in step from one section to the next, so you have these anomalies throughout the system. But we're here to, look at the code, what's presented before us, and then make a decision based on that. And from what I see, the applicant made their case.
Mr. Simmons?
I want to hear what
What Mr. Snyder and Ms. Eckert have to say?
what Lisa has to say.
Well, he must see, okay,
I don't
Ms.
know.
Eckert.
So, there's clearly a conditional use in place for a nursing home. Conditional uses, as we all know and understand and recognize, run with the land. So, we are not privy to the case back in, I believe it was 1990, or 1990, if that's the accurate representation. So we are left with, we have approval for a nursing home. It does not ever go away. So the only question for me is if this use meets the definition of a nursing home. And to that end, Mr. Voigt, the Carroll County zoning administrator, who I have utmost respect for, indicates that it does meet the criteria for a nursing home. That's his interpretation. And I think that there was sufficient evidence, notably the definitions, the general definitions relative to the code, that suggested that is an appropriate conclusion.
Mr. Snyder?
First of all, thank you for everyone coming today. It's always very important to have the citizens participate. Council, you both did an excellent job. I'll babble just a little bit, if I might. I know at the beginning of this case, Mr. Nelson said it's basically looking at the legal interpretation of what a nursing home is and whether this particular facility applies. And I think based on words, that he lost that battle. With that said, words mean something. And when I say words mean something, it's not only the actual words, but it's the context in which the words are said, for what reason, and what is the intent and timing of the words relative to what we're speaking to. Meaning, when we had the approval back in 90, I've at least tried, for a nursing home, were they the words that were used to approve this particular nursing home conditional use? I don't know the answer to that. Or were the words, when you put a nursing home, were the words used for the definition of a nursing home specific for a specific reason, but why the writers use them? I know, because I have some exposure to this industry, many of those words are key words used in the COMAR to basically get nursing homes bed counts. Okay, meaning that they have to show a population with these issues in order to be able to have them be admitted, okay? And that's all in the COMAR reg. So again, I always question sometimes authors' use of certain words. And did the people in 1990, did the board in 1990 even remotely envision treatment centers? I can assure you they did not. Had they, would they have written the words differently? I don't know the answer to that either, but it really gives me pause. Because I'm looking back, and the decision does give us some insight into the mindset of the board, where it says, specifically says, experts in the field of real estate and vehicular traffic engineering substantiated that the proposed enlargement would not adversely affect the surrounding community. Well, we have a document now that says there is somewhat of a traffic issue. It further says that nearby residents and property owners support the request. And I think that's really a key element, in the thought process of the board back then. Although I can't put myself in their mindset, it does give us some insight into what they were thinking and what the community as a whole was thinking at that time. Interestingly, COMAR regulates both treatment centers and nursing homes. So you have a common agency that regulates both. On the flip side, it's disappointing a person who has a $13 million project and wants approval for this particular facility can't articulate what government agency regulates COMAR. I think that's unfortunate. Nursing, we have the nursing aspect because if you remember, I inquired regarding staffing. And is there RN, is the staffing model include medical professionals such as RNs and so forth? And it does. So we're back to the definition, nursing. As a board, we're restricted within the four corners of what the code says. We can't just arbitrarily write the rules from here, okay? The county commissioners and the planning commissions and committees develop the zoning in this county, and we can't walk outside the four corners. So with that said, and I say this reluctantly, I would have to support the approval because it's in the four corners and the way the code is written. If it was written any other way, then we would have some flexibility, but the code is the code.
Ms. Eckert.
She already answered.
Oh, I'm sorry. Mr. Simmons.
That's okay. Thank you, colleagues. Essentially, I summarized it as, is a drug rehab facility a nursing home? Or it confuses me, and I've only been here since 9 in the morning, so I've got 8 hours or 7 hours of using my brain or trying to get my brain around this. And one side says one thing and one side says the other, and I go back and forth and back and forth. Does this definition, nursing home, fit the case today? I think it does. Could it have been written better? Well, back in 1990, I don't have any idea. I know that the drug treatment needed now is substantially different than what was needed in 1990, having been around in both eras. And worked in drug treatment in both eras. I just have to say, the code is being rewritten as I think over the next 6 months. And certainly other definitions will be included, at least I hope so. But for now, I have to say that I want to make an affirmation that the previous definitions confirm that a residential addiction service facility is permitted under previous approvals for a nursing home. And that's where I'm going to land.
Okay, this is a troubling case in my mind. I think it's unfortunate that we even have to be looking at rehab facilities. This isn't the first one that we've dealt with in the last, I guess, 8 or 9 months. There are numerous uses out there in all districts that don't fit the strict definition that we have. Contractor storage yard, Holy Toledo. There's a whole host of things that can be done. We've tried to clean that up. The only place we're looking at here is a nursing home, and Mr. Nelson didn't quite go far enough in his nursing home definition. It says a residential healthcare facility which provides institutional lodging, nursing care, personal care, and supervision to the aged, chronically ill, physically infirmed, and then the word or, convalescent patients. And the convalescent patients, that was defined. We had the definition before us. I don't know what other definition you could have. We're looking at, we've learned a lot as a board here about level of clinical treatment, and this is a level 3.5. This is not the detox part of it. And I was glad to hear that these were not court-ordered patients. That's a whole nother, that can create a whole nother set of circumstances that could be detrimental. So we're looking at a 3.5 where they need 40 hours of instruction a week. This isn't where they're coming and going. A 3.3 facility, as we learned back last fall, is where people are coming and going. They've got jobs and they come and they get their counseling in the evenings. It's very unfortunate, again, that we absolutely need this. Do I think this fits the definition? Yes, it does fit the definition. The key word there is or. So with that, board, I'm willing to entertain a motion.
I'll do one if you wish. In case number 6447 before the Board of Zoning Appeals, that the board approve the request for affirmation and potential modification of the Board of Zoning Appeals' previous decisions to confirm the residential addiction facility is permitted under previous approvals for a nursing home.
Do we leave anything out?
Should it have and potential modification?
I said that, didn't
No, I mean, you did say that. I'm wondering if it should be in there. We're not
What the actual potential modification is? Is that what
Right,
you're?
yeah, we're not modifying anything, right?
We're not modifying the thing because really it's going in as a nursing home because it fits that criteria.
Okay.
it? Strike that.
Okay, do I have a second on the amended motion?
Can I hear the motion again? Can you do it, Richard?
Yes. In case number 6447 before the Board of Zoning Appeals, that the board approve the request for affirmation of the Board of Zoning Appeals' previous decisions to confirm that a residential addiction service facility is permitted under previous approvals for a nursing home.
Okay, do I have a second?
Second.
Okay. Any discussion on the motion? Okay, seeing none, all in favor, aye.
Aye.
All opposed, no. Motion carries. Our oral decision will become final upon a written decision which will be issued within 30 days unless otherwise extended by this board. A board's decision may be appealed by filing a petition for judicial review with the clerk of the circuit court for Carroll County in accordance with the provisions of Chapter 200, Title 7 of the Maryland Rules of Procedure. The appeal must be filed within 30 days of the date of the board's written decision. Thank you.
Thank you.